See, I have filed a notification of a designation of senior advocate, which is not in conformity with the role and contrary to the.
Give the memos.
Yes, my lord. Any day, they have to.
Let us see that.
Item 20. Item 20. That execution appeal. Today your lordship had fixed for admissions. The Advocate General was supposed to appear in that case.
Actually, today I could not. Yesterday I was little occupied. I have not gone through the brief at all. It's a very voluminous. It's around 100 acres of government land is spinning basin. I have to go through the brief. There's lots of. So can it be taken up? There is no urgency. After vacation.
Which for the other side?
Go through the.
Which for the other side?
Senior Mr. Gautam Mukherjee is appearing.
Please.
I'll inform them.
Just make them aware. We are not saying anything.
Well,
At the time of call also you can.
Another one. That special bench matter. Your lordship tomorrow for tomorrow.
Yes.
I may probably in the night to Delhi. So I didn't know. I was about to cancel because of the war, but it has now, there is a ceasefire, so I have to go. There is an important Pathat matter, which was fixed on 13th, I didn't know which one was 13th. Because the special bench will take an action rule and it will.
That was fixed on your request, Mr. Advocate General.
No, well, but I could not take up that day.
Because then the entire hearing on the other day would be.
There is London bench matter. After that, this was supposed to be taken up.
You were there because
Minor Justice Raman is also there.
we heard it substantially, I think.
Almost over.
No. It was at the verge of completion, I believe.
That's a top almost hard.
That police manual or something. Yes,
We wanted only that whether that is a rule of law.
absolutely.
Resting interpretation it depends on how. Divisional bench already decided that whether it is correct or
Oh,
not. To decide.
I think virtually you have completed the arguments. You have done it. Only thing is there was some query raised from the bench regarding that manual, whether it has got any statutory flavor. Because your submission, if we correctly remember, was that it is being applied, implemented for several years. Now is it too late in a day to raise a question on that? So we wanted that there must be, and we are sure there should be some kind of a powers to frame those rules.
I guess the rules, if asterisk is not there, whether that is to be construed as forming part of police manual rules or it is outside. Because the editor's note shows that asterisk mark portions are only construed to be declared under Police Act 1861, Section 7. So that is the question which came from the bench.
Really, I didn't get the opportunity to interact. It's so much. That is the problem.
Keep on with that. Unnecessary.
Will not constitute.
It will be after vacation, what can be done. But only request from the bench is that please ensure that on the next date, at least other assignments should be.
No, that would be, actually, I didn't know. That day, I was thinking some matter is posted on 13th. I couldn't recollect what is that. It was the.
No, ensure any
Now
day.
I kept a calendar inside my pocket. I
Yes.
don't maintain that. I remember it here, but that day I forgot.
Any day which you suggest that availability is there.
Not in a pattern matter there because they at times say that your lordship knows very difficult to.
Yes, after vacation, just give a date. It will not be constituted on tomorrow.
I would have cancelled. I had already told to cancel because of this ongoing situation, but
Anyhow, just suggest a date after the vacation, any date. Please.
Too great.
Yes.
Pardon to
Matter was fixed to 13th of this, on 13th for production of original records, Your Lordship. In the Habeas Corpus matter.
So tomorrow,
Yes, Your Lordship.
uh,
But since there is a state government holiday, Your Lordship, even today, may I request it to be posted on 15th so that I can get the records, Your Lordship. I've spoken to the authority, they say it is closed, but the police authority, but because it's on secretary.
speaks on 15.
On 15th.
Inform the other sides.
Yes, Your Lordship.
So they will come and mention that my matter is not listed today. Please inform.
To mention
Oh,
one,
pleasure.
sir, Honorable Single Judge went this matter regarding removal of Sarpanch matter.
Go there.
I just came from.
From where?
From Honorable Justice B.P. Sarpati, sir.
So
Between today it was fixed. I went there for mention. Since the matter is noticed, it's not getting listed, but the notification for by-election has been released. I have filed the case.
So you go and make a convince. Can we direct
I tried.
the judge that you list the matter and that is not appropriate.
I tried.
Judicial discipline. That's
Because
he
only 4
could
days-
not you could not convince him that there is an urgency, sir. If you could persuade us, I am sure that you could have persuaded his lordship.
I want to mention
Well,
PIL relating to the alleged death of a suicidal death of a foreign national Heat University. I've read certain prayers in that PIL.
Give the memo.
This is a
give the memo.
very
Pass on the whatever. Give the memo. Will be.
I'm looking at going to
Yes, sir.
financially.
Please write down the urgency. No difficulty.
For delivery of orders, item number 1.
I may be permitted to mention I'm on VC, my lords. But on PIL matter, I pray before your lordship.
Please give a chat box, sir. Every matter is important for us.
My lords.
Yes, we'll see to it.
All right.
My lord, I'm on BC, my lord.
What?
I'm on BC, my lord. Am I audible, my lord?
Sir, audible, visible, both, sir.
Thank you, sir. Sir, one thing is that item number 15, my lord. That is the.
See, sir, let us start the roster. I think we'll be able to reach 15.
So what is the convention? I failed to understand, sir.
What?
Never before happened here. Once delivery of order of consent is there, that's received everything. If you don't call that before pension.
My lord.
Anyhow, the matter is already listed. Let it be called. Yes, we are at the delivery of the judgment.
My lord, I am speaking from Rourkela. M. Malesh from Advocate, my lord.
We have held that since the entire selection is vitiated, the authorities are directed to make a fresh publication or advertisement for engagement of an Anganwadi worker in that particular center, strictly in terms of paragraph 3B of the said guidelines. And the event the suitable candidates are not found, the engagement shall be made taking into consideration the modified paragraph 1 of the said guidelines. The entire exercise has to be completed within 3 months from the date of the communication of this order. You peoples have not really worked hard. You peoples draft the petitions without looking into the entire aspect. Leave it to the court to do everything. There was a notification making an amendment. You did not refer that amendment. Go through the judgment. Amendment has been brought. EDM has been given a power, not the sub-collector. In 2009.
10.
9. 10 also. We have quoted those.
They were not brought to the notice of this.
Absolutely. Had it been brought to the notice of the single bench, the order would not have come. Yes.
Item number 2.
Please, Your Lordship, my lord. Your Lordship had framed this question, Your Lordship recalls, whether the writ court can interfere with the order passed by the tribunal in exercise of section 16 or should it be strengthened of permitting the parties. Lordship has the order, my lord. But before that, Your Lordship had raised one point for more of an academic point, which I have researched. I can give Your Lordship the answer before coming to this, if Your Lordship is concerned. Your Lordship had also asked whether a section 9 application is maintainable, although whether, when there is a stamp adjudication. Your Lordship wants, I can give the answer to that.
What? No, that was an ancillary point because I find that none of the judgments have really taken except the special bench of the Bombay High Court.
But
Nothing.
now there is a sentence in Interplay which confirms this.
That is very dicey. I know that's Justice Rishikesh.
We will leave that.
Justice Rishikesh Roy's observations in the judgment, but I believe it again open a big Pandora box.
My lord, we need not go into that, my lord, since what that is taken. May I proceed to the main matter, my lord? My lord, before I come to just 5 minutes on the facts, my lord, and the order of the arbitral tribunal and then the order of the High Court. My lord, this is a case where there was an, according to us, agreement for sale in the year 2004. The year is important. And at the time of the agreement for sale, there was no mining lease at all. We were the buyers, the persons, Mr. Tarini Mohanty were the sellers, allegedly, agreement for sale. So after the date of the agreement for sale, they were to get a mining lease, and the mining lease came later, and then they were to supply whatever raw was there, and that raw would come out, and then that raw would be crushed and graded and all that, and then the delivery would take place. This is the rough factual background. Yes. Now, the arbitral tribunal held, in my view, my lord, absolutely correct, my lord, Justice A.K. Patnaik. He analyzed Article 5 and Article 23 of the Stamp Act. Article 5, as your lordship knows, is generally agreements. Article 23 is conveyance. So, to constitute a conveyance, the instrument which contains the arbitration agreement has to pass the title. It's a very simple question. And his lordship, my lord, the arbitrator
has to pass through a muster of the conveyance.
That's right. That's it. Has to pass, muster the test of conveyance, the particular instrument which has the arbitration agreement. And in the view of the learned arbitrator, which according to is absolutely correct, this is an agreement for sale for all which would come out of the ground in future, and then there would be a contract for sale later on. Therefore, this did not come within the meaning of conveyance as defined in Article 23. This is sum and substance. May I just show your lordship 3 paragraphs of the tribunal's order. Lordship, and it comes to the writ paper book. Paragraph. I'll just show your lordship very shortly only the relevant paragraphs, my lord. Page 34. Page 34, my lord, annexure 1 to the writ. My lord has it. My lords have it. Yes. So, if your lordship comes straight away,
this is an application under section 16 of.
Yes. The respondent filed
to rule the jurisdiction.
My lord.
To rule the jurisdiction.
That's right. To rule the jurisdiction, it was the intention of the respondent after the pleadings had been completed that according to the respondent, since this was a case of conveyance, it had not been properly stamped under Article 23, and therefore it should be impounded and sent for stamping, and the arbitration could not proceed. This was sum and substance of the contention. Now, kindly comes to paragraph, my lord, 30 onwards. At page 46.
Yes.
Paragraph 30, I'm not placing. Paragraph 31 is Article 23 conveyance. Paragraph 32. Oh, para 30, very well, why not?
No, I have read it already.
yes. So
He
I'm
has
not-
raised an issue,
That's right.
not
As I indicated-
adequately stamped.
And then 32, the contention of respondent, section 210 defines conveyance to include a conveyance or sale, etc., etc. Then 33, the respondent has read upon this judgment. Now 34. Real reasoning starts from 34. 34 is the Sale of Goods Act, makes a distinction between contract of sale and sale, and further makes it clear the contract of sale or agreement to sell becomes a sale when the property in the good passes from the seller to the buyer. Section 4 and 5 of the Sale of Goods Act are set out. Your Lordship is familiar. And then in paragraph 35, it refers to installment supply, which we relied on. Supreme Court relying on section 4. The term contract of sale includes an agreement to sell. An agreement to sell is known as executory contract for sale, while a sale is known as executed contract for sale. The term contract for sale thus includes both actual sales and agreement for sale. It is important to distinguish clearly between the two classes of contract. An agreement for sale is a contract pure and simple, whereas a sale is a contract plus a conveyance. The basic distinction, Your Lordship. Then, my Lord, Khurana brothers relied upon by them. Essence of sale is the transfer of property from one to another as per section 4, etc. Essential feature distinguishes the contract for sale from agreement to sell is the contract for sale. The property is transferred from the seller to the buyer immediately, whereas an agreement to sell, property is transferred on a future date. My Lord, the concept is made clear. This state of Uttaranchal was a case where there was an auction. There were certain cases of resin oil which were already there. And the court held that since it's an auction, the title will pass as soon as the hammer falls because everything is, the price is there, the goods are there, they're deliverable, and you have confirmed. I'm summarizing the case. Position of law has been reiterated, paragraph 37. Agreement for sale is not a conveyance. Then, kindly come to paragraph 38. Now the reasoning. The Arbitration Tribunal finds that the first agreement with the claimant and respondent was made on 12th February 2004. The agreement is titled Agreement of Sale of Iron Ore. Kindly see paragraph 38 and particularly clause 1.3. In the event Cisco refuses to purchase iron ore either by itself or nominees, Mr. Tarini Prasad Mohanty shall be entitled to adjust the value of the ore against the advance unsold ore. So if some portion of the ore which comes out of the ground is not taken by me, he will adjust the advance and sell it to a third party. So it contemplates sale to a third party also in certain circumstances. So on the day of the sale, on the day of this instrument, it is not ascertained as to which part will be sold to a third party or myself. In any event, etc., etc. Now, para 39, my Lord, the reasoning. Subclause 1.1 of the agreement dated so and so shows that Tarini Prasad Mohanty during the tenure from the start of the mining operation shall sell and Cisco shall purchase the entire iron ore excavated from the mine of Mr. Mohanty. Subclause 1.3 of clause 1 further provides, in the event Cisco refuses to purchase iron ore either by itself as nominee, Mr. Mohanty will be entitled to adjust the value of the unsold ore and advance, and in the event of such advance not sufficient to cover the value of the uplifted ore, Mr. Mohanty is permitted to sell such uplifted ore to a third party as is sufficient to cover the undisputed amount. Thus, it is an agreement whereunder the respondent has agreed to sell to the claimant iron ore excavated from the respondent's mine. By the aforesaid agreement, there is no immediate sale or transfer of iron ore from the respondent to the claimant. Under the agreement, the respondent has agreed to sell in future iron ore which is excavated from the respondent's mine, and in case the claimant or his nominee does not purchase the uplifted ore, the respondent has the right to sell the uplifted ore to a third party. In other words, the claimant has not acquired any title to the ore excavated from the mine on execution of the agreement of 12th February. No conveyance or sale or immovable property was responded to the claimant by the said agreement. So this is the reasoning. And then kindly comes to para 40. By the agreement and the supplementary agreement, etc., etc., the mine owner shall sell and purchase the entire ore. None of the agreements subsequent to the sale agreement have provided that the title of property in the iron ore, Lordship kindly sees, para 41.
Excavated from the mines of the respondent.
Yes. The transaction has remained also an agreement to sell excavated ore and not a sale of conveyance. Then, my Lord, para 41. Para 41, 42, 43, 43, 42 is the contention of the respondent that the sale agreement dated so and so and all subsequent agreements or conveyances for transfer by way of sale are covered by Article 23 is not correct. Claimant, on the other hand, submitted stamp duty. Now, my lord, Article 43 sets out in Orissa what is the relevant article as on the date relevant that time. Now, of course, may have changed. So, B is Article 5C, where under C, if not otherwise provided for, 10 rupees. Article 23 is on conveyance, my lord. Yes. According to the claimant, therefore, the agreements were to be stamped with stamp duty of 10 rupees. All agreements between claimant and respondent, including the agreement, are made and stamped at 100 rupees. They are therefore sufficiently stamped. And they are sufficiently stamped. Arbitral tribunal finds merit in the contention of the claimant. So, in passing, your lordship is familiar. I'm not going into all the details. With the Sale of Goods Act, there has to be, my lord, ascertained goods in a deliverable state for title to pass. Now, here the goods are not ascertained. They will come out of the, first there will be a mining lease. On this date, not even the right of the seller has fructified, leave alone the right of the buyer. Mining lease will come. 5 years later, the mining lease came. Then the ore will be taken out. The ore will be crushed. The ore will be graded into 2 categories. Then there will be a weighment. And then the question of title passing may arise. At this point of time, there are no specific goods in a deliverable state ascertained under Sale of Goods. That's under the general law. I'm not going into the details. This is very basic general law. The arbitrator has gone by that, and the arbitrator has also held that if some portion of the ore which is to be excavated ultimately finds its way to a third party, then the question of the entire ore being transferred to the title doesn't arise. This is the reasoning of the arbitrator. Now kindly comes to the reasoning of the High Court, my lord. Yes. That's in the appeal paperwork. That's at page 38. My lord, at this stage, I'm deliberately not going into the details in the law regarding the stamp because I believe that may not be so relevant at this stage. My lord, page 38 is the judgment of the single judge. Starts at page 38 in a writ petition under Article 227. Kindly comes to, I will not take your lordship. 32. Issues for consideration. Before I come, so one of the issues was whether it can interfere or not at page 51. And I'll come back to that, the issues. But first, my lord, on this very short question of the stamp, what the tribunal, the court had to say. So that is at paragraph 74. Now kindly see, my lord, with respect, totally contrary to, my lord, the basic law that it is the instrument only which has to be looked at. It is pertinent to know the sale agreement entered in para 74, my lord has. Yeah. It is pertinent to know that the sale agreement entered into by and between the parties has been acted upon in the sense that 89 purchase orders have been issued by virtue of the understanding contained in the sale agreement. My lord, this has happened 10 years or so later after that agreement, which is totally irrelevant. The purchase orders have been issued in performance of contract conditions and have to be read as a part of the contract, my lord. Totally wrong, my lord. The only document which my lords should look at for the purpose of the instrument is the sale agreement, the agreement for sale containing the arbitration clause. No other document which comes 10 years later has any relevance to this one. It is clear the agreements have been acted on and form a concluded contract. My lord, anyway, agreement for sale is acted on and the sale contract is issued, that is normal. That does not make the sale contract the agreement for sale. Basic distinction, my lord. Intention of the parties make it clear, minerals so excavated would stand vested in the petitioner for 10 years. Well, they cannot stand vested in the petitioner because on the date of this agreement, the ore has not come out and the ore does not even belong to the lessee. Commensurate with consideration already fixed and paid. This is also incorrect. It was only an advance. The price is not even fixed. It is erroneous and perverse. This arbitrator has merely relied on the title without endeavoring to examine. Conveyance of the goods has been done and nothing remains to be performed. My lord, in my respect, was completely wrong, my lord. This has completely missed the point that whether the instrument which has the arbitration clause passes the title or not. It's gone into some purchase orders and other things. And my lord, following this, the court held at para 77 that this a right has been created and the right of the petitioner's sole and exclusive advance had been given, which could be para 77, my lord, which could be utilized in case the petitioner was not able to purchase the ore. My lord, I have not understood with respect how that passes title. Meanwhile, meaning thereby all ore was excavated in a sense paid for. My lord, this is the reasoning of the High Court. Now, and the direction, my lord, is interesting, my lord. Para 88 is the direction. Not being content with holding that it is liable for duty, the 89, arbitral tribunal has to mandatorily impound the agreement which is not duly stamped. After arbitral tribunal, after impounding the instrument, will forward it to the collector. The collector shall then direct stamp duty at 5% of the sale agreement and levy penalty. Well, this is not with respect the area of the High Court, because I have many other defenses like limitation and 4%, 5%. There are many things. This was totally beyond any authority. Only you could have impounded and sent it. This is in passing one. In this record, they clarify the collector, while determining the stamp duty, will take the summation of 89 purchase orders as a sale agreement value. Lordship kindly sees. The 89 purchase orders did not even exist at the time of the sale agreement. Agreement for sale. The purchase orders came so much later, and that too against the purchase orders, some 20-30% actually were delivered. So this has absolutely no relevance at all. For stamp, it cannot be some document which comes 10 years later after the instrument. This is totally illogical. There makes no sense. Endorsed instrument should then be returned. Till such time, the arbitration will remain in abeyance. So, well, with respect, on merits, completely wrong. I wanted to show your lordship. Now, on the issue, with respect, the arbitrator was fully right. Basic first-year law sale of goods. And with greatest of respect, the High Court was completely wrong. Talking about purchase orders 10 years later, stamp on the purchase order, original instrument, passing the title, everything has been done. All the ore has been vested, all with respect, factually totally wrong. Now the test, now we are coming to the test. Now the arbitrator himself, the High Court itself at paragraph 60. I'll show all these judgments in due course. Paragraph 60 kindly sees the High Court considered the situation and when should the High Court interfere against an order under section 16, paragraph 16.
Yes.
Your Lordship has paragraph 60.
Yes.
Yes. This is a verbatim reproduction of Justice Pratibha Singh's judgment, Surinder and the Delhi High Court, paragraph 25.
Yes.
Yes. Now, kindly cease. Arbitral tribunal is so-and-so. For ground number 3, for interference under Article 227, there have to be exceptional circumstance. Though interference permissible, unless an order is so perverse, it is patently lacking in inherent jurisdiction. My lord, it cannot be anyone's case that the arbitrator, while exercising jurisdiction, patently lack the jurisdiction to decide the stamp matter. Interference is permissible only if the order is completely perverse. Perversity must stare in the face. The justice arbitrators, it must be just by reading it, your lordship should feel this is so perverse, has to go. The High Court also discourage litigation which necessarily interferes with the arbitral process. Excessive judicial interference in the arbitral process is not encouraged. It is prudent not to exercise jurisdiction under 226. The power should be exercised in exceptional rarity or there is bad faith. Efficiency of the arbitral process ought not to be allowed to diminish. Interdicting the arbitral process should be completely avoided. But not every single test given by the court, all the tests are correct. Now, applying this test, this result cannot be reached. All these tests, neither is it exceptional rarity, nor is there bad faith, nor is there any question of perversity staring in the face, nor is it patently lacking in jurisdiction. All these tests, if lordship, applies this test, this result cannot follow. So this is the first thing I'm showing. Now I'll show your lordship the actual judgments which lead to this paragraph 60. Well, very shortly. Well, I've given your lordship a compilation. The compilation. If my lordship takes SBP first, my lord. Seven judge bench in SBP, right?
Yes.
Which, of course, on other issues may have been modified by the administrative function and judicial, but on this issue, it is still the law. Paragraph 12 first.
Yes.
I'm sorry, my lord, it was my duty to have shown the act first. I think your lordship, but still 5 minutes just before I come to this. So the context is there. Section 5. Notwithstanding anything contained in other law for the time being in force in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Section 5. Then section 16. 16 is very important because it's really turns on 16. The arbitral tribunal may, section 16(1), arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement, and for that person, purpose, etc., etc., etc. Kindly come to subsection 2. A plea that the arbitral tribunal should not have jurisdiction shall be raised not later than the submission of statement of defense. However, a party shall not be precluded from raising such a plea merely because he is appointed or participates in the appointment. Here it was done later, but anyway, we are not getting into that. Then 6 is most important. A party aggrieved by such arbitral award may make an application for setting aside such arbitral award in accordance with section 34. Now I'll show your lordship. The judgments are very clear that since you are not remediless, you must wait for section 34. This is what the judgments say. Sorry, my lord, subsection 5. The arbitral tribunal shall decide on a plea referred to. Yes, I'm sorry, I should have placed that.
No.
And it should continue with the arbitral proceedings and make an award. Most important, my lord. Sorry, I missed it. So you decide the plea.
Subsection 7 will only be activated if after rejecting or ruling out is jurisdiction proceeded and then making an award. Then subsection 6 comes into play. That plea can be raised at the time of section 34. But if in the midst of the proceedings, say the award has not come, then what is the right of a party?
I'm sorry, Mal.
Please consider the question is that what are the rights of the parties? Section 16, it says that there is no fetter on the part of the arbitral tribunal to rule its own jurisdiction. There is no difficulty. If such plea is decided on subsection 5, then in that event, the arbitral proceeding will continue if he rules on a jurisdiction and then proceed to make an award.
Which is what he has done here.
Correct. Make an award.
He has done.
And then if the award is there, then it is not precluded from challenging that particular plea or taking a plea under section 34. Now, in between in the interregnum period, what would be the remedy? Does it foreclose a complete remedy or some exceptional, something new? What? One has to understand.
May I try to address your
when you just place the summarization and says those are correct,
yes.
Then in that event,
I tell you, lordship, I'll place the.
Then what to do?
Yes. the rule is that when your jurisdictional challenge is rejected, the general rule is you will have to wait until the award is passed and agitated at the section 34. Nothing else can happen. That is the general rule. I'll show your lordship the judgments. I was going to show that.
No, these are the general proposition that has come.
And in
exceptional cases, that is
in
what is
exceptional cases,
that is there.
That is not there in SBP. That has come by reason of further judgments. I'll show your lordship. In those very rare and exceptional cases, although none of the Supreme Court judgments which have considered it have allowed the rare and exceptional case. It has not happened so far in the Supreme Court. But theoretically, there may be such a rare and exceptional case where your lordships intervene in 226 even before the section 34 stage happens. That's the answer.
That is what is happening everywhere, sir. When this amendment under the Codicil Procedure in 2002 was brought, keeping the amendment under Order 8, keeping a time limit of 90 days within which the written statement is to be filed. And then this Kailash versus Nanku came from the Supreme Court.
Observed in the breach. Your lordship is observed in the breach.
Then if Kailash versus Nanku says in an extraordinary exceptional circumstances, the court is not denuded of power in extending beyond the 90 days.
Correct.
Calcutta Amendment is 120 days. But 90 days, that is permissible. Everybody is now bringing it
but
with the exception.
this, so far I have seen,
So test
there is no statutory interference with the section 16. It is by judge-made law subsequent to SBP. I'll show your lordship the condition. Then your lordship will decide why I tell you this finer tuning was done by the Supreme Court, because the argument was made that 226 is so very wide that whatever the statute may provide, whatever the non-obstante clause, whatever the exclusivity, arbitration being a full, complete code, whatever the time limit in arbitration and expeditions process, still then theoretically 226 cannot be completely shut out. This is the logic of the court, man. And therefore this rare and exceptional, all the rest of it. Man, may I just now go to SBP, man, because I believe a 7-judge bench of SBP to some extent should still hold the field.
Yes.
Kindly comes to paragraph 12 and then 45, 46, 47. May I read, my lord?
Yes.
Para 12. Section 16 of the Act only makes explicit what is even otherwise implicit, namely the Arbitral Tribunal constitutes the Act as the jurisdiction rule on its own jurisdiction, including ruling objections with respect to the existence of validity of the agreement. Subsection 1 directs an arbitration clause form part of the contract treated in the agreement independent of the other terms. It clarifies the decision of the tribunal, the contract null and void shall not ipso facto, ipso jure, the invalidity of the clause. Subsection 2 enjoins the party wanting to raise the plea that he has to raise it, not less the submission of defense. Section 3 lays down a plea the arbitrator exceeding the scope of authority shall be raised as soon as the matter is alleged to be beyond the scope of authority. When the tribunal decides these two questions, the question of jurisdiction, the question of exceeding the scope of authority of either of them, the same is open to immediate challenge and appeal when the objection is upheld. And only in appeal on the final award when the objection is overruled. Subsection 5 enjoins that the arbitral tribunal overrules the objection as subsection 2 or 3. It should continue with the proceedings and make an arbitral award. Subsection 6 provides the party aggrieved by such award overruling the plural jurisdiction and exceeding the scope of authority make application on these grounds for setting aside the award in accordance with section 34. So this is the principle in paragraph 12. Now, paragraph 45, 46 and 47.
This is really a reiteration of what transpires from subsection 5 and 6.
Now, kindly come to paragraph 45, 46 and 47. 45 and 46 read.
Yes.
It is seen, kindly, page 663, paragraph 45. Very important, my lord, because this is what the SBP holds.
Yes.
It is seen that some high courts have proceeded on the basis that any order passed by the arbitral tribunal during arbitration would be capable of being challenged under Article 226, 227 of the Constitution. We see no warrant for such an approach. Section 37 makes certain orders of the arbitral tribunal appealable. Under Section 34, the aggrieved party has an avenue for ventilating its grievances against the award, including any in-between orders which might have been passed by tribunal acting under Section 16 of the Act. Your Lordship's question. The party aggrieved by any order of the arbitral tribunal, unless has the right of appeal under Section 37 of the Act, has to wait until the award is passed by the tribunal. This appears to be the scheme of the Act. The arbitral tribunal is a creature of contract between the parties in the arbitration agreement, even though if the occasion arises, Chief Justice may constitute based on. But that would not alter the state of the tribunal. It will still be a forum chosen by the parties to the agreement, by agreement. We therefore disapprove of the stand taken by some of the high courts that any order passed by the arbitral tribunal is capable of being corrected by the High Court under 226 or 227 of the Constitution. Such an intervention by the High Court is not permissible. So this was a blanket ruling in SBP of 7 judges. Now, this is what they said. Now, let us come to the further developments, my lord. Then we come to, my lord, 46. The object of minimizing judicial interference, my lord, while the
I've already read it.
You've read it, lordship. So this SBP was very clear. SBP left no window open. No 226, 227 business. You wait till the award is passed. This judgment of 7 judges, very clear on this. Now let us see, my lord, deep industries.
What would happen? Suppose the very basic point of jurisdiction is raised, and it says that the arbitration clause itself is invalid or null and void. Then in that event, one has to just wait, and the entire exercise is to be undertaken. And then in 34, ultimately the court found that this point of jurisdiction is there. Then it's a farcical exercise, and one is to be financially burdened more.
Correct. Now, may I answer?
You have come across 230 sittings of the arbitral tribunal.
No, I am only saying this is.
You have come across.
This is why
230th sitting of the arbitral tribunal.
Well, this is why the window has been. This is why the window was probably given by the Supreme Court later. But may I answer your lordship's question? May I answer your lordship's question?
100 sittings.
Suppose, I'm just testing out what your lordship is saying. Supposing an arbitration agreement with respect to property A, and the arbitrator proceeds to B, and the agreement, yeah. So then, possibly, as your lordship says, merely by looking at the arbitrator's decision, just by looking at it, it is so glaring and so obvious that this cannot stand. And this should not be allowed to continue to the award stage. Maybe an argument is possible. I concede that, my lord. It's possible. But that will be, my lord, just be exceptional and extraordinary. Now, if your lordship, it has to be on the face of it, except. That's right. Now the embargo has been narrowed to exceptional and extraordinary. I am coming to those judgments, but the question is then, your lordship will have to see whether this is a lack of inherent jurisdiction and exceptional and extraordinary. Obviously, and that's why I placed the correct. So we are not, my lord, on an abstract case here. We are on a specific case of stab. Correct. So now.
With the hypothetical example, it's to be given so that at least we should know.
Yes. So I've given your lordship a hypothetical example. For example, that's what property A, property B, the arbitrator has. Correct. So you go into 226. The court says this is so obvious.
There are many instances where the arbitration agreement itself is a void one.
Correct. My lord, your lordship is absolutely right. So in those exceptional cases, your lordship may feel that the court was right in interfering. But that has not happened very often. I'll show your lordship in these 3 Supreme Court judgments, it didn't happen. In the judgment of the Calcutta High Court, Justice Patnaik's judgment on stamp duty, he also did not interfere. And in the judgment of the Orissa High Court, also no interference. I have not as yet found too many cases. In fact, I have not found one. There may be somewhere of some reported judgment where they have interfered. It may happen. I may have missed it. But it is exceptionally rare. The idea is it is very, very rare, and it must be so absurd on the face of it if your lordship finds that the arbitrator's reasoning, which I placed before your lordship, future agreement, it is so absurd that just by looking at it, one has to brush it aside. That's the test. Nothing higher. Not even the test of patent illegality in section 34. Not even that level. Higher level. I'll show your lordship. These are exceptional rarity. In bad faith, no allegation of bad faith. The shocks the conscience. Inherent jurisdiction, he obviously has to decide the question of stamp. My lord, doesn't fit any of the categories. In my respectful submission, that stamp duty argument is absolutely correct. Only if your lordship first has to find it is incorrect, and so incorrect that it is an incredible and view which nobody can possibly have taken on the face of it. And then, of course, your lordship, the jurisdiction to interfere now is given by the subsequent judgments. This is the sum and substance of the law today, my lord. May I just place it very quickly? Deep Industries, para 118. Page 118. Of the compilation, page 118. Yeah. So I'll not trouble your lordship with the full judgment. Your lordship comes to paragraph 16 onwards. Most significant of all is the non-obstante clause contained in section 5, which states that notwithstanding anything contained in the law, matters as part 1, no judicial authority shall intervene except provided in the part. Section 37 grants a constricted right of first appeal against such judgments and no others. The statutory mandate also provides for one bite of the cherry and interdicts a second appeal. Then para 17. This being the case, there is no doubt whatsoever if petition will be filed under 220-27 against orders passed in appeal, entire process will be derailed, would not come to fruition in 2 years. At the same time, we cannot forget Article 220, the constitutional provision which remains untouched by Section 5. In these circumstances, what is important to know, the petition can be filed against judgments allowing a dismissal first appeal, yet the High Court will be extremely circumspect interfering with same, taking into account. That's right. Inherent, patently lacking jurisdiction. Then your lordship will come to paragraph 19, SBP. It follows SBP. And then, my lord, paragraph 22. Kindly says para 22. This is interesting for the factual analysis also. One other feature of this case, some importance. As stated here before, section 16 application had been dismissed by the arbitrator, in which substantially the same contention found favor with the High Court. Lordship has it. The drill of section 16 is that where a section 16 application is dismissed, no appeal is provided, and challenge to section 16 being dismissed must await the passage of a final award, at which stage may be raised under section 34. What the High Court has done in the present case is to invert the statutory scheme by going into exactly the same matter has been gone into the arbitrator and decided this so and so. So exactly that has happened here. The High Court in 226 has gone into exactly the same matter as they gone into the arbitrator and taken the contrary view. Exactly what had happened here. For this reason alone, the judgment and appeal needs to be set aside. Kindly cease. So you cannot reverse on a factual analysis. Even otherwise, for a pointer, judgment goes into merits of the case, etc., etc., etc. Entering to the general thicket of dispute of parties does not behave a court exercising jurisdiction where only jurisdiction errors can be created. As your lordship said, it goes into the patent lack of jurisdiction area. So you cannot reverse. You cannot go into an agreement, analyze section article 5, article 23, go into the reasons. For these reasons, this one, court says, no, this is all wrong. I find this is advance has been given. This is or as a title. This analysis is not in inherent lack of jurisdiction. Doesn't come within it. 23. And then 23, we reiterate policy of speedy disposable arbitration, etc. And then 24. Mr. Roy is only correct, pointing out legislative policy requires general revision amendments made 115 to 20. When a revision lies, it's only against final disposal, not against the interlocutory orders. That's a general, that your lordship. That is not really so germane for this case. Yes. That's right. Your Lordship is right. So I'm not clear. Kindly come to the next one, MTA, my lord, page 133. Para 3, 4, and 5. Very short judgment. According to Sri Vishwanathan, one look at the joint venture agreement and the arbitration clause would make it clear third party in the case had not been referred to at all, as a result of which there is patent lack of inherent jurisdiction within the meaning of deep industries. We are of the view that a foray to the writ court under section 16 being dismissed by the arbitrator can only be if the order passed is so perverse that the only possible conclusion is that there is a patent lack in inherent jurisdiction. A patent lack of inherent jurisdiction requires no argument whatsoever. It must be perversity of the order that must stare one in the face. This is the level at which, my lord, the interference will come. The lordship would have to see Justice Patnaik's, the tribunal's order and say, this is absurd, it's staring me in the face, this is nonsense, has to go. Just that. Nothing more argument should be required. Unfortunately, the parties are using the expression which in a judgment deep industries to go to matters which do not suffer from patent lack of jurisdiction. Instead of dismissing the writ petition, the High Court would have done well to have referred to judgment in deep industries, dismiss it on the ground, no perversity. It leads to patent lack of inherent jurisdiction. High Court should have dismissed with heavy cost and the imposed cost of 50,000 Supreme Court. So this is the same theory of initial lack of jurisdiction stare in the face in MTA. Then my lord Bhavan, the last third Supreme Court judgment, page 136. Here they contended the arbitration was time barred and under some other act. So paragraph 5, they took the objection under section 16 and the arbitrator rejected the application, paragraph 5. Then aggrieved, the respondent filed written 226, 227 and the High Court held so and so. And the Gujarat High Court correctly held, my lord, that this is not maintainable, not required to entertain. Only remedy available is to wait until section 34. And now they have come to the Division bench allowed it, my lord. Then the matter reached the Supreme Court. Now kindly see paragraphs 18, 19. Question paragraph 11 is the question raised. Having heard both the parties, the question which needs to be answered is whether the arbitral process could be interfered with under 226, 227 and under what circumstance. Then paragraph 20, sorry, my lord, 20, yes. Deep industry 90, 20. Has not been able to show exceptional circumstances of bad faith. So, the test is exceptional circumstances of bad faith. What sort of exceptional circumstances has been said? Patent lack of jurisdiction. You can't reverse the arbitrator's order on merits. And 22 also, High Court did not appreciate the limitation to 26, thereby and reason that the appellant had undertaken, thereby rendering the respondent remediless. Plain reading points to the fact the appellant actually acted according to the procedure. This on the merits. So now, my lord, on conspect, these are the 3 Supreme Court judgments. Then I think your lordship, I'll take your lordship to the, because Delhi High Court and all that is there. I'll take your lordship the Calcutta High Court judgment, because that is a stamp case, page 173, actual stamp case. Objection on stamp. 173, MD Creations, Justice Vivas Patnaik in the Calcutta High Court. Paragraph 2, at the end, raise the objection, section 16, impound the agreement and send the agreement for stamping and registration of authority. The application under section 16 was dismissed. Identical facts to this, exact case. But here, of course, it was reserved for further evidence. You can try again. Then kindly come to paragraph 9. The arbitrator, though dismissed the application, kept the issue with regard to unstamped para 9. Hello? If the issues regard unstand document open, defect is curable, and such aspect can be decided upon evidence. So there they left it open for evidence, but they did not allow the objection. Then, my lord, paragraph 14 is Deep Industries, 15 is Bhavan, 16. Kindly sees what the reasoning was in 16. According to the above observation, McDowell doesn't be considered, and then only it can be challenged by the arbiter, and then only under 34 and final. 21. That's right. And paragraph 19, patent lack of jurisdiction, 21, exceptional circumstances. And this was not one of the exceptional circumstances, and it was dismissed. I'm not troubling your lordship with it. There's also an Orissa High Court judgment at page 187, Division Bench of Justice Murlidhar. To the same effect, your lordship may very quickly look at running page 193, paragraph 34 of Justice Murlidhar's judgment. Same proposition, para 34. Deep Industry in Bhavan consistently hold only when the High Court is satisfied that it is remediless. Here it is not remediless. The rarest of rare cases exercise jurisdiction, etc., etc. And Nivedita Sharma, then the bottom in italic. This power needs to be exercised in exceptional rarity, wherein one party is left remediless, or clear, here it is not, or clear bad faith is shown by one of the parties. High standard set of this court is in terms of the legislative intention to make an arbitration fair and efficient. And it was therefore para 35, not remediless, chose to that. It is no allegation of bad faith. They could have gone under 34. And no opinion to the challenge of 34. Left it open. So this is this High Court. And then, my lord, the 7-judge judgment in Interplay, if your lordship sees finally. The book is before your lordship. 2024 6 SCC. One of the one which overruled NN Global 2. 2024 volume 6. Running page 76, your lordship comes straight away. My lords have it? Yes. Para 131. Section 16 empowers the tribunal to rule on its own jurisdiction, including ruling on any objection with regard to the existence of a validity agreement. Importantly, the parties have a right under section 16, 2 and 3 to challenge the jurisdiction. 131. 131. Yes, may I read it again? Internal page 76, paragraph 131. Yes. Yes. Once the tribunal, yes, it is not the arbitral tribunal obligated to decide on the challenge, and where it rejects the challenge, it can proceed with the arbitral proceedings and make an arbitral award. It is the principle of procedural competence. Competence is recognizing the power of tribunal to hear and decide challenge jurisdiction. Once the tribunal makes an award, section 16(6) allows the aggrieved party to make an application setting aside under 34. Section 16(5) and 16(6) further show that Parliament has completely ousted the jurisdiction of the court to interfere during the arbitral proceedings. Courts can intervene only after the tribunal has made the award. So, going back to SBP, another 7-judge bench doesn't leave this window up to it, although doesn't consider the question directly. Section 16 intended to give full effect to the procedural substantive aspects of the doctrine of competence.
I
don't think at some stage, maybe when the occasion arises, on 184. Para 184 once in finally, my lord, just one more paragraph. 184, 93. This is on purpose, of course, but it is only the definition, not only the definition of arbitration, also other provisions in the Act, purpose for which is enacted that make it a special law. As observed by this court in Bhavan construction, which I showed you, arbitration is a code in itself, detailed mechanism to ensure success, speedy and efficacious alternative. The main objective is to comprehensively cover so. So, if you now hold this up, my lord, by allowing these interventions by 226 courts, it impedes the arbitral process. That's the general reasoning. And they are not remedialist, they will do it at section 34. And the narrow window which has been indicated has not been exercised by the Supreme Court in any of these three cases. Neither the Orissa High Court has shown your lordship, and the Calcutta High Court on the stamp issue has clearly held stamp is not an issue of a patent lack of jurisdiction, we will not interfere. And in any event, the test is so high that your lordship, that's why I showed your lordship the learned arbitrator's reasoning, that it must be so absurd and he must have patent lack of jurisdiction, which he does not. It must be exceptional rarity, which it is not. And the court must be convinced that no other view is even possible and it is the only possible view. Something more than that maybe. And on merits, of course, I have not addressed your lordship in great detail, but reasoning with great respect, which says that because you have to take all the or, even in spite that you have given an advance, when the or comes, you will get it. And therefore, the title has passed on the instrument and the purchase orders have to be added up, which have never seen the light of day at the time of the instrument, my lord. It is, on the face of it, if anything, it is the High Court's order which is so perverse that stares one in the face of the arbitrator's orders. For those reasons, I very respectfully submit that, of course, one can decide the issue of the stamp here, but that is not the correct procedure. This should be left to be decided. Arbitration should continue, and this should be left to be decided at the stage of Section 34 as the scheme of the Act and all these judgments contain. In the facts of this case, it's not an exceptional rarity case. It's not a patent lack of bad faith case. It's not a patent lack of jurisdiction case. Well, those are my submissions.
May I please, your lordship? Lord, may I answer the question straight away? There's a direct judgment which I'm going to show, which this is the query which fell from the court, but may I just summarize my submissions at the very outset? Point number 1. Can a writ petition lie against an order passed by the arbitral tribunal? Answer, yes. In what circumstances will it lie? It has to be exceptional in a case when there's patent lack of inherent jurisdiction. Lord, para 206 of the interplay judgment addresses exactly the question that the observation that my lord made. I'll just come to it in a minute, straight away. That when a document is inadmissible under the Stamp Act, section 33 and 35, you have to first, I'm emphasizing on the word first, make good that deficiency before adjudication. Therefore, section 7, as my lord rightly used the expression, you don't want a farcical exercise, you don't want 230 sittings. The stage is settled by section 16. And lastly, at a very practical level, by way of an analogy, a petition is filed in a court. There is a defect. The court doesn't adjudicate the matter and then say, go to the registry to cure it. Therefore, 16, when there's a patent lack of jurisdiction, that if the document is inadmissible, it is curable, go and pay the appropriate stamp and come back. Don't undertake the entire journey, which is the exercise in futility, time consuming, eating precious time, as well as depriving the revenue of my lord stamp. So the Constitution Bench judgment clearly says that, look here, it is public policy, namely that if a document is inadmissible, it is public revenue which is at stake. Therefore, first make it good and then adjudication. So the stage is also settled by that. So this query, my lord, answers the question. And I will show the single judge has noticed the test which is to be applied in terms of the parameters laid down, arrived at a finding, my lord, that it is exceptional. And all that it says is, look, go and pay the appropriate stamp and come back. Now, without prejudice to this, in their own statement of claim, from their own pleading, they rely on the sale agreement to say that he has, my lord, a sole and exclusive right. The entirety of the ore goes to him. 81 or 89 purchase orders have been issued. It is fully acted upon. This is his own pleading in the statement of claim, and then saying the respondent, that is me, is in breach. So this whole argument today, with greatest of respect, is a clear afterthought to now get over the stamp issue. But his pleaded case is different. So with this, I'll be able to satisfy my lord straight away. Now, my lord, kindly have, just to hit the nail on the head, if my lord could have para 206 of the interplay judgment. Yes, if whichever is convenient to my lords. Lord, I'm answering first purely as a proposition of law for my Lord's kind convenience so that we know what the settled position of law is. And I also have prepared a chart to show that all the judgments that my learned friend relied upon have stood overruled in this. So this was the only relevant and applicable thing. Let me show that straight away for my Lord's kind consideration. May I just request if my Lord, though it's on a separate point, takes para 199 first. May I, with my Lord's permission? Lord, with your permission, may I? I know you're faster than me, but I'm just trying to keep pace. Lord, may I just read 119? Yes, exactly. Lord, it's so squarely on point. Is my Lord at para 206 or 199? Both. So, my Lord, may I just for my satisfaction only read this one line since my Lord is ready. Interests of revenue are not jeopardized in any manner because, now this is crucial, duty chargeable must be paid before the agreement in question is rendered admissible and the list between the parties adjudicated. That is only a section 16. There's no other way in which that can be flagged before the tribunal. So, my Lord, it has not only decided the proposition, it has also clearly indicated the stage list before the list between the parties is adjudicated. So, according to me, Lord, this is squarely, clearly on the point. Yes.
Where is this link between the parties?
Now, when you want to cite an interplay judgment, so may I extract that point of the word interplay?
Yes.
Between section 33 and 35 of this chapter.
Please, man.
It has, if you look at this section 33 and 35.
Yes.
Practically, these are the same language.
I'm grateful.
It does not, except a very noticeable
Acted upon.
distinction, which will appear in section 35.
Shall be acted upon.
Acted upon.
Precise.
Acted upon is there only.
Correct.
So in that event, there has been a debate on that.
Correct.
The debate was really first flagged off by a Supreme Court in SMST.
Correct.
And then in the meantime, there has been some departure. Departure was.
Because you say the link between the parties and all that.
Reiterated subsequently. Then what is the meaning of the word acted upon?
Yes.
Acted upon means that as per SMST,
it
says that you cannot make any further step into it.
Correct.
You have to just stand
So what are you
still.
reading?
Yes,
At
sir.
stage.
Precise.
That a document is tendered to be received in evidence. The function is the document is evidence is a very important matter.
Correct.
Now, I on that day, just out of the context, I have raised that issue to Mr. Here, that what would happen at the interlocutory stage, what happens? Is it the receival of the document is evidence, or it has to be construed in a more conservative manner? Where a witness is standing in a witness box and then tendering the document to be received, the
Correct.
evidence.
Correct.
So, if that conservative views to be taken, then in that event, the interlocutory stage
Will never
does not
come.
arise.
Correct.
Because it is decided on an affidavit evidence.
Please, man.
It is only at the time of again, it will be a very, I would say, very complicated or very debatable word, a trial. Now, the trial is also defined in a very different manner.
Open-ended manner.
In a conservative way of defining the trial is when the issues are settled and then the witnesses are called and they are adducing an evidence. It's normally construed as a trial.
Correct.
But I am aware of one Supreme Court judgment of 1950s says from the date of the presentation to the judgment is the entire process is trial. So that's why it's a
That's it.
debatable point. So I do not know. Now the question is that if it cannot be acted upon, then should the arbitral tribunal stay its hand till the document is impounded? If he says that no, I will proceed, whether this particular decision of the tribunal under section 16 comes within the folds of that exceptional or an extraordinary cases, or I would say inherent lack of jurisdiction.
Patent lack of jurisdiction. Please, man.
So that the 226 or
Yes.
27 can be.
I'm grateful.
Can be invoked.
Yes.
This
Yes.
was the larger issue.
Absolutely.
Really, according to him, it is not an exceptional circumstance.
Yes.
And let us see whether it comes.
Yes,
or-
I'm grateful.
Found.
Yes. Can I just also request my lords to have para 199? So you've read it because
Yes.
my starting point can be from here. So may I just request my lord to have para 199? Yes.
Yes.
Yes. Now, my lord, this is exactly what fell from the court. So I'm testing that. Once the arbitral tribunal has been appointed, like in this case, it will act in accordance with law and proceed to impound the agreement under section 33 of the Stamp Act if it sees fit to do so. So I pause for a minute. I take the simple interpretation of the court. Here is a tribunal. The moment it is constituted, it will act in terms of law and proceed to impound the agreement under 33 of that if it sees fit to do so. Correct, Manoj? So it clearly shows that you're constituted, act as per law and impound the document, and we'll come to this order. Second, it has the authority to receive evidence by consent of parties in terms of section 35. So as my lord rightly says, 33, 35, 35 has the added word and shall be acted upon. So, my lord, with greatest of respect, let me give a scenario, contextual, of course. The moment a document comes which is inadmissible, and this is my word, according to me, it can't be touched. Therefore, a tribunal will say, look, I hold my hands. It is now curable under the Supreme Court judgment. Please go and pay the requisite stamp and come back. Versus, let's test it. You go through the whole prolonged journey, and your lordships have given a good example of 230. We've all experienced that. 200 plus a good cricket score goes on. And then you say, no, this actually is to be impounded. I set the clock back. The entire process which has gone on, time, cost, money, law, everything goes. So simple, practical thing. I look at it. I think it falls under Article 23 of the first schedule. Please go and cure it. Solution, not a problem. Versus, I prolongate the journey. So first submission to answer my lord's question. Yes, the answer will be section 16 that the tribunal will not take any further steps. It will, using my lord's expression, come to a halt or stand still so that this issue is addressed and it can proceed further. And therefore, my lord, if my lord notes that in this judgment also, in the conclusion, at para 235.4, below of this very judgment, yes, please have para 108.
108 or 235.
Page 108, but I may go by para so that I'll just go with para. Milord 235, it says conclusion. I'll do it in reverse order with my lord's kind permission. Please have 235.4 to verify well from my lord, the Chief Justice. Any objection in relation to the stamping of the agreement fall in the ambit of the tribunal. No doubt. Now please have 235.1. Agreements which are not stamped or inadequately stamped, our case, are inadmissible in evidence under section 35 of the Stamp Act. Such agreements are not rendered void or void ab initio or unenforceable because the next one says this is a curable issue. That is what this judgment now says over all the other judgments. It is yes, correct. It's void. Correct. Correct. And now, my lord, please see very interestingly. Just this is a side way, but just to show some light. My lord, kindly see 235.3 from a different point of view. An objection to stamping does not fall for determination under 8 or 11. This is important. It doesn't say 16. So 16 is open to get into the issue of whether or not, you know, the document is properly stamped, because that touches on the jurisdiction of the tribunal. You cannot touch an inadmissible document. It remains inadmissible as long as it is inadequately stamped. That is overruled. Just, let's see the last para. Just 1 second. 235.5. The decision in NN Global, SMST are overruled, Garware are overruled to this extent. So today, Interplay, if I may use the word, holds the field. Interplay, in my humble and most respectful submission, gives complete clarity on the issue which my lords are presently deciding, minus the merits of the case. And that 206 is a clear answer. These conclusions are a clear answer. It is in the domain of the tribunal. And if the tribunal thinks,
if the application is made for appointment of an arbitrator.
yes,
And the court, I mean, whatever, the chief justice or the court.
yes,
Is nominee.
yes,
Would not go into.
No.
Stamp duties or.
Yes.
That document, whether attracts any stamp.
yes. 235.3.
That's
Ex-
what I'm saying.
Absolutely. Correct, ma'am.
So it will be left at this stage of the receiving the document in evidence.
Yes, ma'am.
Correct.
Exactly. And this tribunal, therefore, is now in session of the matter. And the tribunal has to decide this issue in my respectful submission upfront for the reason I indicated.
Provided
Yes.
the wanted the receive such evidence. Suppose the parties choose not to.
Yes,
Rely on an agreement.
exactly.
Then in the agreement, it does not put a feather.
Yes,
Arbitral agreement.
yes, correct.
But no, there will be other agreement. which
Precisely, ma'am.
attracts the stamp duty but not paid.
Precisely.
And
Section 16.
And my lord, with greatest of respect, I'm so grateful. Kindly see the language of 16. The tribunal may rule on its own jurisdiction. It's the tribunal which may rule on its own jurisdiction.
No problem.
My lords have almost seen your observation is 138 of this judgment exactly says what fell from my lord. May I just read it? It's not. In case the issue of stamping is raised before a tribunal under section 33 and 35 of the Stamp Act, making it evident that the person having authority by the words you used, consent of parties to receive evidence, is empowered to impound and examine an instrument. A person having authority by consent of parties to receive evidence includes an arbitral tribunal which is constituted by consent of parties. Exactly what my lord said. Para 138, perhaps it's at page 78. But so that's just my lord to answer. So my lord, with greatest of respect now, may I just formulate my point? I've also brought a written note of submission. And lastly, in May 2025, an order is passed by this High Court entertaining a writ against a Section 9. Section 9, when there's a statutory remedy. So, just bear with me for a minute. Very interesting. Just one point he made. So, against a Section 9, a writ is filed. Although there's a 37. Writ court gives an injunction. Matter goes to Supreme Court. Supreme Court formulates questions of law, including one which my lords are deciding, but finally says no. Since ABC happens, the Section 9 court will decide. I.e., 227 court gave relief. Supreme Court did not interfere with that relief, confirmed that relief till the Section 9 competent authority decides. So my learned friend said, there is not a judgment to show that relief was given in 227. This is of May 2025 vintage. Even where there was a statutory remedy, even then the High Court entertained 227. But I'm just correct.
Yeah.
But I'm sorry, with greatest, I'm making two further points in addition to that. Number one, court actually granted relief. Point which my learned friend in the end, just in passing, said, oh, none of those cases gave relief. I'm giving a relief case. Second, my case is on a higher footing because it was not like a 9 challengeable in a 37. Even then, the High Court did exactly in deference to what fell from the court. This seems to be the lay of the land on the legal framework and the principle. Now, my lord, may I just quickly summarize the position and then show the order of, may I take my lord to the single judge first, because how he's addressed this issue.
That has been done correctly. Doctors cannot be said to be not addressing the evidence.
Please, madam.
Interplay between the and that also is a very important one.
Absolutely.
But the interesting thing is that though everything has been touched upon, but the one really important section subsequent to section 39 was not completed on. Suppose for any reasons, the documents have already been received in the
Yes.
then it cannot be challenged at a later stage of the proceeding that those ought to have been stamped.
Yes.
This was not done.
Correct. Absolutely.
That means that even by consent of parties, one can receive those documents in evidence and they forego a particular plea often stamp. So
Not relate.
it is a mandate of the on the court.
Exactly.
Not of the party.
Exactly. Because it says, I'm so grateful. Constitution bench also recognizes.
36 has not been taken.
Yes, yes. But your lordships are right. It's the mandate of the court because it says it's the interest of revenue which is important. So court will take note of it, forget the parties. Now, my lord, with this, may I take my lords to the order of the single judge, if my lord could have page 70 of the writ appeal paper book. Page 70. Lord, para 60, if I may advert to it by paragraph numbers. Yes, without the impugned order, para 60. Yes, 60. Am I on the right page? Or the same page as the court?
You are referring paragraph.
Not 60. Very. A perusal of the decisions, my lord, will come to the case law which I have indicated, that the following principles are well settled in respect of scope of interference under 226, 227 in challenges to order by a tribunal, including orders passed under 16. Now, my lord, he notes it and kindly have Roman 3, 60 Roman 3. It has to be an exceptional circumstance. Yes, my lord will just for a minute only note the answer is at page 84, para 87. The answer. That why it's an exceptional circumstance. So he applies in my respectful submission the correct test. Right? Just only note here for a minute. Page 84, para 87 is where the answer is given. Now, my lord, kindly note a few points. If my lord comes to page 72 for a minute. Lord, he notes section 2, subsection 10 of the Stamp Act, which is the definition of conveyance. Then, my lord, he notes the clauses of this agreement. Now, I'd like to just read out, my lord. In the statement of claim, which had been filed by this party, which I'll hand over, it was before the single judge, just read one line. As per the sale agreement of 2004, the claimant, which is the appellant before the court, had 100% rights over the excavated ore from the mine of the respondent with a profit-sharing regime upon the sale of the same.
Young matter. What is he placing? Paragraph?
Your lordship will see, it says statement of claim. Does it have a number 25 on top?
There's not been a run page. That's when you get it.
6.1. If my lord has para 6.1, it says dispute and subsisting cause of action.
6.1.
Yes. But there will be a page number on the right side on the top, 25.
Wow.
It doesn't mean the title pass. Right, Manoj? May I just so let's see what his case on the agreement was, which he is now like a chameleon changed his color. That as per the sale agreement, the claimant had 100% rights over the excavated ore from the mine of the respondent. So claimant is the appellant before the court with a profit sharing margin of 70% upon the sale of the same. There is a specific covenant in the agreement that the respondent had agreed not to sell or otherwise part with or dispose of any iron ore from the leasehold mine, and has further agreed that the claimant shall be the sole buyer during the continuance of the said agreement. And my lord, when I place 1.1 shortly, my lord will see it talks about the entire ore excavated, which the court says gives you a right of vesting. This doesn't end here, my lord. Please have just below that 3 lines. The ore from the leasehold mine, and has further agreed that the claimant, I call it appellant for my lord's convenience, shall be the sole buyer thereof. So his understanding of the sale agreement based on clause 1.1, 1.2 and 1.4, my lord, is that he has 100% rights and he's the sole owner. That clause, my lord, is 1.1 of the agreement. I'll just read it for my lord's kind convenience. The respondent shall, during the period of 10 years from the start of mining operators, sell to the appellant who shall purchase the entire iron ore from the respondent. Yes, exclusivity clause, entirety clause. Now, my lord, kindly have page 27 of this.
Page 27.
My lord has it. Para 6.5, that as per clause 1.1 of the sale agreement, the claimant was entitled to an undisturbed purchase of the entire iron ore on a monthly average after 12 months of operation from the leasehold area without interference or interruption or demand whatsoever. Now have 6.6 at the bottom of the page. However, there was a negligible supply of iron ore from the respondent to the claimant against purchase orders placed by the claimant before the respondent. So it is fully acted upon. He places purchase orders, gives advance. This is his own pleading. Now, my lord, kindly come back to the order of the single judge. At page 74. Uh, 70. Yes, madam.
Yes.
Now the court will look at the true intention of the parties by examining the agreement itself, as it is settled in law that the title of the agreement is not indicative of the true nature of the document. Then, my lord, he sets out the recital in which the key words are entire output of the mine as the sole buyer. So appellant is sole buyer and the entire quantity goes to him. Now, please have the next page, my lord, that is clause 1.1, which I was referring to, extracted here for my lord's kind convenience. Page 75, para 71. The respondent shall, during the period of 10 years from the date start of the mining operation, sell, and the appellant shall purchase the entire iron ore excavated from the mine of the respondent. Then, may not kindly have the next page, 76, para 72. Subclause 1.1 of clause 1 of the agreement shows that the respondent during the tenure from the start of the mining operation shall sell and the appellant shall purchase the entire iron ore excavated from the mine of the respondent for an exclusive period of 10 years. The seller was injuncted from selling to any third party during that period. Now kindly have para 74. It is pertinent to note that the sale agreement entered into between the party has been acted upon in the sense that 89 purchase orders have been issued by virtue of the understanding in the sale agreement. The same purchase orders have been issued in performance of the contract conditions and have to be read as part of the contract itself. It is therefore clear that the agreements have been acted upon and form a concluded contract within the Indian Contract Act, my lord, and Section 4 of the Sale of Goods Act, which talks about sale and agreement. Then, my lord, kindly please see the next paragraph. The intention of the parties is abundantly clear that all the minerals excavated from the mine of the opposite party would stand vested in the petitioner for a period of 10 years, commensurate to which the consideration has been fixed and paid. Therefore, it is perverse that the arbitrator has relied on the title of the document without endeavoring to examine the true intention of the parties and the manner in which the contract has been worked out between the parties. The conveyance of goods in question has been done. Nothing remains to be performed in future upon fulfillment of any contingency. When faced with a similar situation, the Supreme Court in state of Uttaranchal versus Khurana Brothers held. The short question which arises for consideration is whether the above contract for sale of crude resin amounts to a conveyance as defined under Section 210 of the Stamp Act, and if the answer is in the affirmative, whether the stamp duty is chargeable thereon. In order to answer the question, the true and real meaning of the document needs to be ascertained. When we look at the contract, it would be seen that in consideration of the price stated in the contract, the state government agreed to deliver the specified quantity of resin to the petitioner. The parties agreed that the quantity may increase or decrease by 10%. So, my lord, he goes by the nature of that and then finally says, my lord, that as per Section 4 of the contract, which includes an agreement to sale, it's a concluded sale and brings it, my lord, under 2.110. If my lord comes to the last 3 lines of the para 79, that this is a conveyance under Section 210 and chargeable to stamp duty under Article 23, Schedule 1B. This court, now I'm reading para 77 at page 79. This court, in view of the discussion above, concludes sale agreement and agreements amounts to a conveyance within the meaning of Section 2, subsection 10 and is chargeable to stamp duty under Article 23, Schedule 1B. The terms of the agreement between the parties leaves no doubt that the essentials of transfer are satisfied. A right is created in favor of the petitioner, corresponding to which the opposite party has to deliver the quantity of minerals specified. Moreover, the right is sole and exclusive. It is also pertinent that an advance had been given, which could be utilized in case the petitioner was not able to purchase the ore, meaning thereby that all the ore that was excavated was already in a sense paid for and remained vested with the petitioner. So, my lord, with greatest of respect and humility, I say, being a conveyance, it would attract duty under Article 23, Schedule 1B. Therefore, the court concludes, my lord, if my lord now comes to page 84, para 88. Para 88. In the light of the aforesaid discussion, keeping the settled principles of law in mind, and for the reasons given above, the court is of the considered view that the impugned order merits interference. The tribunal has to mandatorily impound the agreement, which is not duly stamped as per Article 23, Schedule 1B of the Indian Stamp Act in terms of Section 33 and 35 of the aforesaid Act. And this, my lord, as I said, on the other part, he refers to in para 85, 86 at page 83. Reading from, para 84, my lord, at page 83. The Supreme Court made a significant observation about the purpose of the Stamp Act and the manner in which it is to be interpreted by court when it observed that the Stamp Act is a fiscal measure enacted to secure revenue for the state on certain classes of instrument. It is not enacted to arm a litigant with the weapon of technicality to meet the case. The stringent provision of the Act are conceived in the interest of the revenue once the object is secured, and according to law, the parties taking his claim on the instrument will not be defeated on the ground that the initial defect in the instrument. Stamp Act is a legislation enacted in the interest of revenue. It must be interpreted with due regard to its purpose. Then he relies on the 7th judgment, and my lord, in para 87, at page 84, he says the present case therefore comes within the exceptional case. What is the patent lack of inherent jurisdiction, my lord? It is that the order of the tribunal is in the teeth of 33, 35 and the declaratory judgment of a 7-judge of the Supreme Court. So he says it falls in the exceptional circumstances. Under 33 and 35, I have to impound the agreement. I impound the agreement, send it to the collector, and after he makes up the sufficient stamp, the matter will proceed. That's exactly the purpose, my lord, of section 16 as well of the Arbitration and Conciliation Act, which is for the tribunal to rule on its jurisdiction. And this being my lord, a case where it had, which goes to the very root of the matter, namely, can you even touch this instrument, which is inadmissible? This goes to the root of the matter. And my expression, it's better to nip it in the bud at the beginning of the journey, akin to institution of a suit in a court. You haven't paid, my lord, duty or there are defects. The court doesn't say adjudicate the matter. And at the end of the adjudication, put the clock back and say, go to the registry and cure the defects. The court will say, go cure the defects, pay the whatever is the court fee, then come for an adjudication. So the sequence is very clear. Otherwise, you'll have a long farcical inning, both time consuming, cost, and to the detriment of the revenue, because it's an inadmissible document, which, as the Supreme Court has noted, and that's how it reconciled the Stamp Act and the Arbitration Act to say, Mr. Tribunal, you're the competent forum to receive this document. You will decide on its admissibility, and if it violates 30 and 35, you can impound it. So the order of the single judge, my lord, is squarely within the four corners of both section 16, the judgment of the Supreme Court, and certainly, my lord, this interplay judgment. Now, my lord, I've just brought a brief note of submission for my lord's kind convenience. Lord, may I just, for my lord's kind convenience, just take the panel because I have largely argued. Lord, the test which is propounded is perverse or exceptional and patent lack of inherent jurisdiction. I think, my lord, that is the undisputed position of law. That's point one. Point two, my lord, it is clear, my lord, that the tribunal did not follow this binding declaratory judgment. That's the patent lack of inherent jurisdiction in our most humble and respected submission. Then, my lord, para 3, Deep Industries case, if my lord comes to the extracted portion, at the same time, we cannot forget that 227 is a constitutional provision which remains untouched by the non-obstante clause of the Act. In these circumstances, it is important that though petitions can be filed under Article 227, judgments allowing or dismissing should be extremely circumspect in interfering with the same, taking into account the statutory policy enumerated by us above, so that interference is restricted to orders which are patently lacking in inherent jurisdiction. So that's the test, and Honorable Single Judge notices this test and applies it and arrives at that conclusion at 87, which I showed. My lord could come now to the next judgment. That is, my lord, Punjab State Power Corporation versus Empla Code, para 4, which is extracted at para 4 of my note. We are of the view that a foray to the writ court from a 16 application being dismissed by the tribunal can only be if the order path is so perverse that the only possible conclusion is there is a patent lack in inherent jurisdiction. This patent lack of jurisdiction requires no argument. It must be perverse in the order and stare one in the face. The moment you look at the pleadings in the statement of claim, read with clause 1, 1.2, 1.4, it stares you in the face that there is a conveyance, and the moment there's a conveyance, Article 23 is attractive. Now, my lord, kindly have the next one. Lord, para 7.
Just look at the notes.
The interplay judgments between section 33 and 35 of the Stamp Act make it evident that the tribunal has the authority to receive evidence and is empowered to impound and examine an instrument in accordance with the doctrine of competence. Further, it is ruled that the duty chargeable must be paid before the agreement in question rendered admissible and the list between the parties adjudicated. So, my lord, I had placed reliance at para 206 of the judgment, which says interests of the revenue are not jeopardized in any manner since the duty chargeable must be paid before the agreement is rendered admissible and the list between the parties adjudicated. So that, with great respect, my lord, gives a clear clue that in cases like this, it must be an upfront examination to arrive at the fact that whether or not it's an admissible document. Therefore, my lord, para 8 is my conclusion. It follows that the tribunal has the authority to rule on the issue of inadequate lack of stamping of an agreement containing the clause under section 16 of the Arbitration Act, and it has authority stemming from the Stamp Act to impound an unstamped or an inadequately stamped agreement, as in the present case. So, as the Supreme Court said, my lord, I have reconciled the two and empowered the tribunal to decide this issue. Then, my lord, kindly have page 4 of my note. Is just for background. All the cases which my learned friend referred to, my lord, I have stated, and in the last column, as your lordship will note, I have pointed out most of them are overruled, my lord, by the decision of the 7-judge bench, which I showed in the conclusion para 234.5. Of my lord's convenience, I've set out all of them are overruled. And SPT, my lord, was in a pre-11.6a regime in any case. So none of that comes to the aid. And the crucial one is the interplay judgment at page 6 of my note.
Yes.
Interplay between arbitration agreement under the Arbitration Act and the Stamp Act. The decision of the 7-judge bench of the Supreme Court is the prevailing law which takes precedence over the aforesaid cases. The relevant paras of the judgment are as follows. So, my lord, I have quoted these two judgments, which says the collector is conferred with the power to impound an instrument under 33. If any other person or authority impounds an instrument, it must be forwarded to the collector under 38(2). In terms of section 42 of the Stamp Act, an instrument is admissible in evidence once payment of duty and the penalty is complete. It stipulates that either the person admitting the instrument in evidence or collector, as the case may be, shall certify by endorsement that proper duty has been paid. Now, my lord, please have para 138. In case the issue of stamping is raised before an arbitral tribunal, section 33 and 35 of the Stamp Act make it evident that the person having authority by consent of parties to receive evidence is empowered to impound and examine the instrument. A person having authority by consent of parties to receive evidence includes an arbitral tribunal constituted by the consent of parties. Now, we will kindly have page 8, where I've extracted para 199 and 206, which I've already, my lord, read from. Yes, so if we can.
Every judge owns a field. Now, I do not say own a field.
Yes.
A field. Then taken into consideration the interplay.
Yes, ma'am.
And now the interplay judge has really authorized it.
Yes.
Some of them has been rendered overruled.
Yes.
Some of them has been retained.
Yes.
Some portion of the judgment is overruled.
Yes.
Some current laws are retained.
Yes.
All these things will definitely come.
Yes.
The question as it comes here.
Yes.
Is a squeeze to one issue.
Yes, ma'am.
Is it so perverse?
Yes. Correct.
That it invites an
Yes. Correct. Correct.
Or it is something which can be challenged at this stage of section.
Correct. Absolutely. I just
look into this.
Yes, but I had to lay the layer.
Either in the scope patent perversity.
Correct.
That is what is. Has it been a case that a document is inherently inadmissible in evidence?
Please, ma'am.
And the question of impounding, not impounding.
Correct.
Well, this document itself is not admissible under the law.
Correct.
But the document which is otherwise admissible. But the documents cannot be received unless You pay this stamp duty.
Yes.
And seeking formalism.
Correct.
This is something the distinction has to be made.
Okay, no, absolutely. So, my lord, we have to lay the foundation for the principles to answer what my lord put to me, and my respectful submission in one line, because I've laid them, is yes, it is such a case which is completely patent lack of jurisdiction. It stares you in the face, borrowing the expression from the court, because a party comes before you with a pleaded case based on a concluded agreement in which the entire vesting has taken place, in which 89 purchase orders have been issued, on which advance has been paid, 33, 35 are squarely triggered. The moment you go against it, you are going against the declaratory judgment of the Supreme Court. Mr. Litigant, this is not for you. This is for public revenue. Therefore, you first pay and then adjudicate. So with greatest of respect and humility, I say, my lord, yes, it's a case founded on patent lack of jurisdiction. There is perversity on the face of it. And the two paras of the Supreme Court expressly say, first pay and then adjudicate. Therefore, undergoing the entire brackets open trial as it fell, the journey, as I call it, the long journey, my lord, would be farcical, expensive, time consuming. It has to be nipped in the bud if it stares us in the face. And this on their pleaded case, the construction of the intention of the parties from the clauses which have happened stares us in the face. It would be nothing but an attempt to hoodwink public revenue to allow this exercise to go. Therefore, 16, and therefore, in my respectful and most humble submission, my lord, the single judge has applied the right test and arrived at an answer. And my lords are aware of Wander versus Antox. The appellate court does not merely substitute its opinion because it may have a different view. So, single judge has applied the right test within the four corners of the law, has examined the matter in great detail, and then arrived at this conclusion. Is my second suraksha point that it is not a case which warrants.
There are two possible.
Yes, correct.
Correct. One adopted by the.
Correct.
Crown Court.
This is my alternate.
Even if the appellate court thinks the other.
I'm great.
Is more.
I'm grateful.
Should not interfere.
Correct. So I'm saying, my lord, I'm first answering my lord's first question to say, yes, it falls in that exceptional category. Yes, it is so perverse that it warranted interference. And I ring fence it by a second fallback, all-encompassing argument to say, if you have a different view, that's not sufficient for it to interfere. It's a well-reasoned argument based on the pleading, the construction of the agreement, and the correct law which is noted. And that's why I showed all those paras to say, you note the right law and apply it. And that would be in line with the interplay judgment, para 199 and 206. And that's how you reconcile the Stamp Act with the Arbitration Act, which was that entire exercise which was undertaken. So what they are seeking to do, my lord, would be to completely undermine this binding judgment, get over a patent lack of jurisdiction, run this whole case, and perhaps at that stage, if the clock is turned back, my lord, by then it's too late as far as the public revenue, that third dimension is concerned, which the Supreme Court says is the overwhelming consideration. So I'm beseeching the court to look at it through that lens, the lens through which the court looked at it, and then, my lord, arrive at this conclusion, as the single judge has done, that yes, it is a case which is perverse, patent lack of jurisdiction, staring us in the face, calling for, my lord, interference, as was done by the single judge. And, my lord, this note also goes through the clauses and the pleading. So it is all encompassing for my lord's convenience, which looks at the pleadings, the contract, the interplay judgment, and in one that comparative parameter, I've showed how it's been overruled. That's just for my lord's kind convenience. I'm extremely grateful.
May I just rejoin very shortly? 10 minutes, my lord. My lord, first and foremost, my lord, this interplay judgment which my learned friend has referred to, which I also showed, my lord, all that, yes, it seems to be under the, some sort of submission seems to be made that is going on saying that the Supreme Court has held it is the duty of the arbitrator to impound this, that. My lord, the duty of the arbitrator is to apply his mind and see whether the document is sufficiently stamped. If he chooses not to do that and he continues, then definitely all those paragraphs which he is talking about will come into play. Arbitrator has applied his mind and held it is sufficiently stamped. That's number one. So none of these things in interplay really. No, of interplay. Para 199 onwards, Lordship kindly says which is referred to. how they are relevant to this case, my lord, I have not understood. May I just show your lordship this paragraph 199? Okay. Yes. And I'll just read them very shortly. Once the arbitral, three paragraphs which he is cited. Once the arbitral tribunal is appointed, it will act in accordance with law and proceed to impound the agreement if it sees fit to do so. Yes. He is not compelled to impound the agreement. If he's applied his mind to the agreement and he says it's fully stamped, he will not impound it. But there's nothing in paragraph 199 to say otherwise. My learned friend seems to be under the impression that the arbitrator proceeded and didn't decide it. He decided it, he said it's sufficiently stamped. Rightly, wrongly is another matter. 199. Then, my lord, paragraph 206. Kindly cease. The interests of the revenue are not jeopardized in any manner, but the duty chargeable must be paid for the agreement in question is rendered admissible and the list between the parties is adjudicated. Question is at which stage the agreement should be impounded, not whether it should be impounded at all. Yes, if he founds at the very earliest when the application is taken, he has to decide it and impound it. He has decided it's sufficiently stamped, he has not impounded it. And my learned friend says by reason of these paragraphs, all those judgments of the Supreme Court have been impliedly overruled. And I really have not understood where the overruling comes. On the contrary, what I showed your lordship, paragraph 131, says specifically, Parliament has completely ousted the jurisdiction the court to interfere in the parliamentary arbitral proceedings. Courts can intervene only after the tribunal has made their award. On the contrary, para 131 of Interplay on this issue is very clear. So on this, lordship is not considered today with the abstract question whether arbitrator should impound, should not impound. He has decided that it is correctly stamped and not impounded it. And the Supreme Court at para 131, after all those judgments, has again said that Parliament has ousted the jurisdiction to interfere and courts can intervene only after the tribunal made the award. That's para 131.
The overruling was in 235.5.
Oh, I am grateful. I am grateful. I am grateful. Let us see 235.5.
At the bottom.
At the bottom.
Yes. Yes. Yes, that is void. Yeah, void, not void. Which stage? Whether the court will decide, arbitrator will. You're not concerned with all this, my lord. Totally irrelevant for this case. The arbitrator has decided in terms of interplay. The court did not decide, the arbitrator has decided. So this judgment, if at all, and 131 it supports me, rest of it is not relevant on the question before my lords. That's number one. Now, number two, my lord, the tests have been given before your lordship. Now, so patent lack of jurisdiction because it's contrary to interplay doesn't arise. There's nothing in interplay contrary. It is in my favor in para 131. So no patent lack of jurisdiction because of this judgment. That's my first question. Then, now, arbitrator has not ignored.
Distinction has to be drawn between erroneous order and a perverse order.
Correct.
Erroneous order, if ever to be challenged to go under section 34, yes. Do it whatever you want to do it, but so far as the publicity is concerned,
Staring one in the face.
The face of it.
That's right. That's right. That's right. That's right. That's right. That's right. My learned recipe.
If you say, at best you can say is an erroneous order by the tribunal,
right?
But it cannot be said to be
correct. And the statement of claim point, my lord, this is not even argued before the arbitrator over the High Court. I don't know, he's fished out a new point, but it doesn't make any difference because statement of claim, lordship kindly sees, what it says is, let's understand the agreement, my lord. I'll take your lordship to the agreement in 2 minutes. He has not got a mining lease. He is saying effectively when the mining lease comes, I will purchase the entire ore. I have an exclusive right to purchase the ore in future. Exclusive right in future. Negative covenant. Arbitrator has also noted that not all the ore may be purchased by me. Some of it may be purchased by a third party. My learned friend has chosen not to deal with that argument at all. That's one of the arbitrator's points. And there is now section, since my learned friend is not, why the arbitrator said this, my lord, very quickly, the Sale of Goods Act, what does it say? When section 18, contract for sale of unascertained goods, no property in the goods is transferred until the goods are ascertained. The purchase order, my learned friend is relying on purchase order. Today, the contract, that agreement, arbitration agreement was in the year 2004. Supposing your lordship was hearing this case in the year 2005. Purchase order has not even come. It just happens that 9 years have passed, some purchase orders have been issued 9 years later. Well, can the purchase order which came 9 years later validate an instrument of 2004? As was the question. Just fortuitous that we are now 10 years later than the agreement. The goods are not ascertained by the purchase order. The goods have to pass on the date of the instrument. Am I clear? This is the question. And the contract for sale, section 18, no property is transferred under the goods ascertained. The goods are in the ground in 2004. The goods belong to the state of Orissa. There's no mining lease. The question of ascertainment, putting section 21, specific goods to be put in a deliverable state, is not in a deliverable state. It's in the ground. It has to come out, it will be screened, crushed, then it will be graded, then it will be put into a deliverable state. Section 18, 20, 21, 22, my lord, very clear, my lord. There cannot be any passing of title in these sort of goods which are underground. Underground goods, title cannot pass, will belong to somebody else. My lord, in any event, these are questions which cannot be said to, inverted comma, stare one in the face. Those are submissions. This is something exceptional rarity, bad faith. This doesn't come, my lord. It will be going far beyond the limits. I'm grateful to that. My lord, maybe pass, give your lordship a short note within.
To supplement with where we have filed a counter claim on the basis of that. That's the record of the lordship's plans. The same paragraph 15, if the lordship says, when you filed a claim, they filed a counter claim on the basis of the same agreement, which they say is now to be. Let's say paragraph 15. No, this was while the counter claim is pending, they filed this application section. What I humbly submit to your lordship, that same agreement is the basis of their claim also. Grateful. Very good. Extremely good.
No, maybe file a written note by Friday if your lordship permits by. I'm blushed.
Very deeply grateful.
Lordship is closing the hearing, my lord. We'll file. Grateful to my lords.
My here is a case where I am appearing for the opposite party number 8 and 9.
Where is the petitioner?
My lord, I am appealing for the petitioner. My lord, here, although this new petition has been filed for issuance of direction for eviction of the private opposite parties, but since in the meanwhile the proceeding has been initiated by the revenue authority.
Enforcement proceeding initiated and it has been
No, let
on the
me-
notice of the honorable.
I need to be.
What
I'll just clarify certain things. I'll just put a lordship kind.
clarify?
Ma-
That no notice should be issued against you.
No, I'm not saying that.
No eviction
Ma-
order
I'm
can
not
be
saying-
passed. No adjudication can be made. You go there.
No, I'm not saying that. Just with your lordship's kind permission, only few lines.
Yes.
On the last occasion on 29th, when I appeared before your lordship, I raised a question with regard to the maintainability of the writ petition. Now, your lordship specifically asked my friend Mr. Jana, his senior, to answer on
Just
the.
suo moto, we can we can treat it as a suo motu proceeding.
Not disputing
If
that.
there is any encroachment,
May
is the encroachment of a government land.
It's an encroachment of a government land. I'm not saying that. I'll only few lines for your lordship's kind clarification. I'm not saying that I cannot be evicted because other encroachers are not being evicted. Let me also clarify that. What I am saying, there are about 30 encroachers whose name I have mentioned. I am present here for your lordship. So I just your lordship, may kindly please 3 minutes. I'll just clarify. Under the
with the Amin, and if they found that these areas, their government land has been encroached by any person, not you.
I'm not saying that a government land. Just 1 minute. I'm not saying that the encroacher cannot be evicted. Encroacher.
I understand. When you think that I am victimized, then why are will have us?
I'm not saying I'm not.
Everybody should.
I'm not also saying that. I'm not also saying.
We are appreciating.
I'm not saying that also. What I am saying, I have remedies under the statute, that is OPL Act.
What is for?
But 2-3 lines more. But I am deprived of that because of this contingency where he files a PIL who is not entitled to file a PIL, and I can demonstrate from his own pleading that it's a PIL at the instance of others. He admits on affidavit which contrary to the.
So what of PIL can be?
I'm not disputing that. But let me just say, in the meanwhile, during the pendency of few lines, it's necessary, my lord. Otherwise, what has happened, I'll just.
What is playing in my mind is a Deepak Mukherjee's judgment of the Supreme Court. I must be very candid.
3-4 lines only. I have to point out that.
It says that illegal constructions and encroachment on the government land, both are the very serious.
I'm not saying that. I'm only saying, my lord, under the OPL Act, and under the Orissa Prevention of Land Encroachment Act.
It is a protection which is given to all those encroachers.
No, I'm not saying that.
Please.
There are provisions of settlement. There are provisions of appeal.
Take care of that.
What has happened? I'll just one more development. I filed during the pendency of the PIL. Not only they issued a notice of eviction. After I filed reply to that, without considering my reply, they issued Form 4. I challenged in the writ petition disclosing the factum of pendency of PIL. Now the writ petition has been disposed of saying that the order of status quo is granted till today. That order I beg to produce for your lordship's perusal, because the Honorable Single Judge said, since a PIL is pending,
so we are disposing of, go before the single.
I have filed an appeal in the meanwhile. I am only praying till my stay application is considered, I may be protected because what has happened. Despite on 30th, the Honorable Single Judge passed an order of status quo, the Government Council over phone communicated to the Tahsildar regarding passing of order. He has demolished a portion of my house. That is why he wants to withdraw the case. Ma'am, I am praying only till my.
Not withdrawing of the case. We are disposing of the case on the basis of this that they have. We will make an observation that all the persons against whom the notice is there, if they are interdicted or protected by any kind of an order to be passed by a court of competent jurisdiction, the authorities will take care of that case.
I'm only praying. Since the order of protection was given only till today, will your lordship only peruse the order?
Go before him to get the same extent.
Unless your lordship, that has been disposed of the writ petition, saying that since a PIL is pending, I am protecting you till 12th. And you raise your point for the specific order, your lordship may kindly see. May I just, your lordship may peruse order is 34/2025. That is at page. I beg to draw my lord's kind attention to page 25 and 26, the order passed by the Honorable Single Judge. Honorable Single Judge has said the petitioners are directed to, the petitioners are directed to approach the said court seeking stay of eviction proceeding. That is this honorable court. No, here, your lordship peruse only paragraph 5, page 26. Yes. In view of such submission made by the Land Senior Counsel for the petitioner, this court is of the view that since the PIL is pending for the division bench of this court,
We
this
can't
would,
stay the eviction proceeding.
they have said,
Yes.
till the next date listing of the PIL.
No, sir, we can't stay. We have that you approach the court to seek for a stay of the eviction proceeding. We can't. You go there, participate therein, unless they pass an order of eviction against
There
you,
has been an order of eviction.
So
That is at case.
then you challenge that.
I have challenged that. I have filed an application for stay that I have indicated in my petition.
Where you before
the sub-collector.
So you go there and
The only thing that may be considered, till then I may be protected. That much I am praying. Otherwise, my lord, already that is a part demolition.
your argument. We are not going to do that.
Otherwise,
Go
my lord,
before the sub-collector and then.
I will go for the sub-collector. I am only saying that, my lord.
No. Under what authority of law can we pass?
No.
I can give you a Supreme Court judgment is against it. It says that when you do not find there is any merit in the, how can you give a protection that till that time you will get a protection?
I humbly beg to submit.
This is deprecated.
Because of the
I am
PIL.
also of the view that no, I will not pass. If your right is clear, I will pass an order
I have
declaring your right.
appeal.
If your right is to be adjudicated somewhere, you go and
Go there. I am not disputing that.
we are not going to give you a protection.
Your
That I am disposing of the proceeding, yet granting you a protection for indefinite
The
period.
only difficulty, not indefinite period, till I avail my remedy, and it has all
We have
occurred of this
understood
PIL, my
We
lord.
understood it.
Your lordship sees, the Tahsildar has demolished my part of my building despite an order by this noble court.
It is really an unprecedented that a writ proceeding is disposed of without deciding the rights of the parties. Yet the interim protection is given till the next steps are taken. The writ court, the party aggrieved by the action of the authority, if approach the writ court, it is an ardent duty of the court to decide whether any constitutional or the statutory rights have been violated by the authority coming within the purview of Article 12 of the Constitution of India. It is not a safest course to protect the interest of the parties and dispose of the writ petition without deciding such rights. The instant public interest litigation is filed alleging that the government land is encroached upon by squatters, and the government is showing apathetic attitude in not taking any steps for their removal. The issue appears to be a larger in the perspective of the state as the government land without any authority of law or a grant issued by the appropriate competent authority cannot be permitted to be utilized. And therefore, it is a duty of the government to see that the land belonging to the government, which are to be used and utilized for a larger public interest or for public good, remain unencumbered, and the encroachers or the illegal occupants should not be permitted to remain thereabout. We do not see any fetter on the part of the government in the event the government take a policy decision to settle the land. But till such time, a policy decision is not taken, the encumbrances cannot be allowed to remain, and the government must resume the land. First of all, the intervener has approached, and the counsel appearing for him is very much vocal in his submission that when disposing of the writ petition filed by his client, the protection against eviction was given till date as the public interest litigation is pending. A citizen of the country is bound by the Constitution as well as the statute promulgated and or enacted by the Parliament or the Assembly. It cannot take the law in his own hand, nor can segregate himself from the clutches of the law applicable to all the persons uniformly. If there is any infringement or the violation of the constitutional or the statutory right, the constitutional courts protects such interests, but not when a person who has violated the mandate of the law having no and violated the mandate of the law and then seeking a protection from the constitutional court, the courts. We thus do not find any justification in the stand of an intervener. Stop. We have been brought to the we have been informed by the counsel for the state as well as the petitioner that the proceeding in accordance with law has been initiated upon identifying the encroachers, and the competent authority the competent authority have found such encroachment without any authority of law, after affording an opportunity of hearing to the parties, to the notices, and passed an order of removal/eviction as permissible in law. The counsel for the intervener submits that the order of eviction passed by the authority is challenged before the appellate authority, and such appeal is yet to be decided finally. The law will take its own course, as the court should not shut the doors of the statutory remedies available to a person. Stop. We therefore observe that it is open to the intervener to approach the appellate forum and seek any protection as available in law. Stop. The public interest litigation is disposed of with the following directions. One, the state shall make an extensive inquiry and or investigation in relation to an encroachment over the government land by engaging the competent authorities, including the army, for relay and survey of the plots belonging to the government. Stop. Upon such exercise, the state, if found the government land to have been encroached upon, shall immediately take steps as permissible in law for eviction and or removal of the encroachers, which should not exceed beyond 3 months from the date of the report of the surveyor / Amin or the other competent authority. 3. The state, after serving a notice as provided in the Act to such encroachers, shall give an adequate opportunity of hearing before it proceeds to take a final decision thereupon. But such proceedings should not be unreasonably withheld, nor should be kept in suspended animation for all time to come. An endeavor must be shown to dispose of the same within a reasonable period of time. Fourthly, in the event of the order attained finality, the removal and or eviction should be ensured by taking adequate measures as provided in the said statute. In the event the statute is silent or an assistance or help of the police personnel for removal thereof, the authority is permitted to approach the police administration for removal of the encroachers and the structures standing thereupon. To stop. Yes, nothing more. It's a omnibus order we have passed before this is.
I refer urgent copy. Urgent copy.
Yes, urgent photostat certified copy of the order, if applied for by any of the parties, be given on a priority basis, preferably within 3 days from the date of the arbitration.
Only urgently, if a lordship mentions 3 days, we can get it today itself. So if a lordship mentions 3 days, they'll not.
You can get it today.
But if a lordship signs it, man.
It will be signed today.
Man. Like, I'm only praying urgent copy. Because your lordship, I have to move the appellate authority as observed by your lordship.
No, you'll have to go somewhere else as well.
No,
that is what we wanted immediately. Because
no, well, not because of that. He can go. He can go.
For making us mention regarding
your office bearers defend us.
my lord, we are not on that, my lord. That item 37, which your lordships had closed the hearing on Friday and kept it for notes. So subject to your lordship, I can just give the notes in the court. And that matter regarding that service matter where after 9 years the imposition of punishment, your lordships heard that matter on Friday, completed the hearing. Item 37, your lordships. Yes. So your lordships had in fact passed the order that the notes to be filed on Monday. No further hearing was required. Lordships can close it on subject.
No,
Sir, copy of the-
I'm just giving it.
yes, for the next.
Item number 4.
Under the petitioner, all the three cases are arising out of one common judgment.
Very good, sir.
Item 5 also.
The written note for it's quite big. Whether the feeling from the press and this the same.
Of course. Item 4.
Under item 4, it means 3 cases and item 5 also. Arising out of one common judgment matter. Here the appellant, my lord, he selected was appointed as a driver on contractual basis against the sanction postman.
Yes.
My lord, under the STM, my lord, there are 14 vacancies of driver. And against all those 14 posts, 14 persons were appointed on contractual basis. And in terms of the annex of page 53, my lord, in terms of 17th September 2013 resolution, contractual employee were completed 6 years of service. They are deemed to be regular. Deemed? Yes. Page 53 also. Page 53. Running post 54, my lord. But it was 2. Clause 2, my lord. Regular appointments on the date of satisfactory completion of 6 years of contractual service and from the date of publication of this resolution, whichever is later, they shall be deemed to have been regularly appointed.
You are talking about the resolution dated 16 January 2014.
17th September. 17th September 2013, that is page 53. Page 53.
Next
Annex of 7 to resolution. What it means? May I place my?
No, we are reading. So the mandate was 6 years in 2013. You were appointed.
Mandate, my lord, 2013.
Yeah,
On the date of satisfactory.
You were engaged since when?
Prior to that.
What is your date of engagement?
My date of engagement is 1/10/2009, man.
So you did not count 6 years.
My lord, I'm coming to that, man. 14 persons were appointed, conferred by the finance department. And my lord,
So they must have 6 years.
that was from the date of resolution or from the date of initial engagement. That was their, my lord.
You just
Yes,
see the
phase two.
conditions of service on regular appointments.
Yes, my lord. on the date of
satisfactory completion of 6 years of contractual service,
or from
or
the
from the date of publication of this
resolution. I was appointed in the year 2010, my lord. 6 years I am completing by 2016. my lord. Or from the date of resolution, it is 6 years.
No, the resolution is, it says that who has completed 6 years must be more than 6 years,
Yes.
or who has completed just on the date of resolution 6 years.
From the date of resolution.
So this is the resolution which was taken on
It is from the
17th September 2013.
That is, my lord, may I, on the date of satisfactory completion of 6 years of contractual service, or from the date of publication of this resolution.
True, that means there are two types of persons.
Employees.
One
Prior
who
resolution.
has rendered 6 years from the date of the engagement, satisfactory completion. Oh, whichever is later.
Yes, my lord. Here, my lord, what happened, my lord? 14 persons were appointed. My lord, during pendency of the rate petition. Here.
To go into this, what would be the meaning of the word from the date of the resolution, whichever is later? Does it mean as a perennial one? Because as it appears, the impression is that from on the date of a resolution, at least 6 years must come.
Well, that has been subsequently clarified. Well, Lordship may find page
Yeah.
54.
Page
54, running page 54 in
Yes.
that resolution. Clause 1, regular appointment. That is subclause 2, last line. The period of 6 years shall be counted from the date of contractual appointment prior to publication of this rule.
No, where is it? The period of
Page 54.
54.
Running page 54. 53 minute that resolution starts. So minute the period of 6 years.
Oh, that is, then it invites two situations. That a person on the date of a resolution completed 6 years of satisfactory service, or a person on the date of a resolution has not completed 6 years of service, but subsequently completed the 6 years of service.
Yes.
Then they both have to be appointed. Then
But here,
how can you disengage?
But here, Lord,
Then position is absolutely clear.
yes,
And
but
this is
there is
what
no
type
quarrel.
measurement measures we have taken in terms of human.
But there is no quarrel to the that.
They have
rule.
done it. They regularized 4 persons.
Out of 14, 4 is regular.
But it appears from the order that these 4 persons were subsequently removed.
Yes.
2 persons. And
4, I think the single bench has said that all the 4 persons have subsequently been removed.
yes.
Then if the mistake was committed and mistake is now rectified, then does it create any right in you?
No mistake.
Then it does not create any right in you.
No mistake, my lord, on that.
That is what how they have removed them.
My lord, during pending, my lord, I have challenged that order, my lord. In
You know, 4 persons who have been removed. You challenge the order? No.
Yes, my lord. We have challenged. In my first and second appeal, my lord, in interpretation, I have challenged the
Are
decision.
you that 4 person?
No, they were regularized and continuing as.
No. The single benches said no. Later on, they have been removed.
They are continuing, my lord. They will say, till date.
What they, sir, recording of the fact in the judicial order is sacrosanct.
Then
You can't contradict.
my lord, there is no such amendment in their counter also.
I do not know if the judge has recorded somewhere. It must be.
And in
Look at
appeal,
the order. I just read it.
in appeal, my lord,
That is there in the Annex or
Page,
they are going to,
24.
my lord.
Come to page 20.
The single benches recorded that.
Yes, but that is not in my counter. That is
No, in the judgment itself.
Judgment, practice of this case is by page 24,
My lord.
clause number 4, clause number 5.
Three, my lord.
5.
Subsequent,
Huh,
my lord, petitioner, myself, my lord.
the petitioner was disengaged.
On 14/10/2022.
No, 4 persons. Where are you? I'm just giving it.
No, he is one of them. He is one of them. So, that's why I asked.
blood, that is blood clause 4, blood, IV, just before that. However, the recommendation made by the Transport Commissioner from Chairman for regularization of petitioner's case, as well as those of other contractual drivers already regularized, was subsequently placed before the High Power Committee. The committee decided to revoke the regularization and rejected the recommendation.
Correct. That is what I read somewhere. So they were also.
They were not, my lord.
But that is,
Till date, they are.
Surplus and idle stock.
no, blood, that is,
On account, that is what, see, people think.
Just come to paragraph 13 of the impugned order. Last sentence. Last sentence.
It is also important to note that regulation of 4 similar situated drivers were revoked for failing to meet the same conditions.
You can't take an advantage of parity.
Well, they are till date, my stand is that they are not,
We have to.
they are, till now they are continuing, my lord. That is, they have never stated in the counter.
What I do not know, but the learned judge has said so.
that is very much there in the counter, Lordship, kindly see page 85.
We are, they are.
Lord, I have
continuing.
annexed that decision of the High Power Committee,
And-
where the
and
appointment
that too,
of
my
4 regularized driver has been revoked.
The bottom line of the story is where.
My lord, in the
what
instant
is to
case,
be
my lord.
done?
In the instant case, my
What is
lord.
to be done?
After their regularization, I approved for the Lorry Tribunal. Lorry Tribunal, my lord, disposed of the direction to regularize that
If
subject.
you challenge that particular the notification or the resolution,
Which resolution, my
the resolution which you were referring 17th of that 2013.
That supports us, my lord. 17/9/2013.
But that line does not support you. That line does not support you.
Because we are completing 6 years, my lord.
No, sir. Is 68 you were talking about, huh?
54, my lord.
The page. Yes, this resolution of 17th September 2013.
My lord.
Please look at it. It's what it says. The clarification has come.
This clarification.
Regular appointment means clause 2.
Yes, my lord.
Last line.
Yes, my lord. This clarification, my lord, relating to for yes, my lord. One, my lord, contractual engagement must have been made against a contractual post created with the concurrence of Finance Department. All these 3 points satisfy the fiction of my lord.
Yes.
That is why.
Sir, you can't take advantage. The period of 6 years is to be counted in that. Anyhow, we are going so hurriedly. Look, the period of 6 years shall be counted from the date of a contractual appointment prior to publication of the resolution. Suppose a person who is appointed on 16th of September 2013. Then on the date of resolution, he has not completed 6 years. Then he has to wait for 6 years to get a appointment. What you are saying, 6 years must be prior to the resolution, no. 6 years maybe after the resolution. Yes, which is better. So he fulfills. He was appointed prior to the resolution.
More than 6 years. Like
He was appointed in 2009, so more than 6 years prior to the resolution. Prior to the resolution. Then how can you deny?
But the conditionality of the rules has not been fulfilled.
What conditions?
What? The petitioners have been engaged as a delivery.
High Court committee has not discussed these things.
Yes, madam.
And what is that condition?
But
You are just
condition
saying
of lordship may
condition,
find,
what is that condition?
condition of lordship may find running page 90. The resolution dated 90. 16 January 2014.
Yes.
What you may find that resolution. As per General Administration Department resolution number such and such dated 17th September 2013. The following are the mandatory eligibility conditionality for regularization of contractual appointee engagements. Lordship finds 2. Such contractual appointments engagement must have been made following the recruitment procedure prescribed in the corresponding regular form. Here, my lord, the petitioner.
These do not take. Already we have decided in many cases. Even writ appeal and single benches, we have all decided.
Their initial entry.
Sir, when you have engaged them, at that time it was incumbent upon you to follow the recruitment process. And you had also some principles you have adopted for that process of selection. You have, because it is for the appointing authority. So appointing authority having not done so, can you, after exploiting the services of these drivers, group D personnel, after certain lapse of period, can you take this plea that work was not followed? This is already SLP against this aspect has already been dismissed also. You prefer SLP. Of course, in SLP there was no direct finding. SLP is dismissed at the threshold. But it is confirmed in division benches. Consistent view was taken. Where we asked you cannot take this plea, and this plea regular recruitment procedure.
But the appointment of petitioners governed under the resolution of the Finance Department under Annex 3 or kindly. But Annex 3 at page 47. On the basis of that resolution, they have been engaged.
What? Where is the resolution?
Running page 47. That is annexed to the writ petition under Annex 3. Running page
2004.
2004.
Yes, what is it?
Last subclause 2. May I read, Miller?
Yes.
But when a sanctioned post carrying a scale of pay is intended to be filled up on a consolidated salary on contractual basis, there could be a possibility of the contract appointee justifying a regular scale of pay in his or her favor on the ground of holding the post carrying a scale of pay. However, on account of the severe fiscal stress experienced by the state, as well as to devote more resources for the development needs of the state, there is a need to move to a contractual form of appointment with fixed remuneration In this context, if any base level vacant post is essentially required to be filled up, the same should be made on contract basis at a consolidated salary. That too only after abolition of the former post carrying a particular scale of pay. The abolition of the regular post and creation of the post at the consolidated salary would be indicated in the same office order so that in future there would be no scope of addition to the same post. And these are the conditions to be imposed. Number 3, the post created on consolidated salary basis would remain valid up to end of February of financial year in which post is created and would automatically stand abolished from 1st March of the said financial year unless the creation of post is renewed after proper review. 4. While considering the filling of any vacant post of exempted category and single sanction post, procedure as outlined in clause 3 above may also be followed with minor modification taking into account operational
What
necessity.
you are talking about, you have reflected in your 17 September
Yes.
2013 resolution.
Yes.
The resolution starts with the post which were created with the concurrence of the finance department. Either the sanctioned regular post is abolished and then the contractual employees are taken, or where the sanctioned budget post is still there but the contractual employees are done. Then you say that in such scenario, 6 years is the period.
Yes. But they must be appointed due procedure of law. There is advertisement.
You did not say in this 2004 resolution
Yes.
that what should be the due process of law.
Lord, here purely contract. Oh, Lordship kindly see
Sir,
clause.
please, when you talk about the Roman 2, when you read it, Roman 2 was considering the state was facing a dire financial stress. He says that these regular posts which had a scale of pay, if anybody is appointed, they may come forward and claim that scale of pay, that I am discharging the same duties and function, please pay me. To avoid it, they say that all those posts, please abolish. And then fill up with the contractual appointees on a fixed remuneration basis. You say that period would be less renewable. There is no doubt. Nothing has been given that how they have to be absorbed. Nothing. If you have appointed with the
What I am trying to
then can you say?
What I am trying, the more relevant is clause 5 and 6. So I am trying to reading from clause 4. Well, Lordship kindly see clause 5 and
What
6.
it says.
Yes, Lord. While making the contract appointment,
Correct.
the appointment order must make it very clear
Correct.
that the appointment is valid up to end of February and a renewal of
That
the
is what
contract.
I read it.
Madam.
And then subject to the performance renewal.
Yes.
You have renewed.
Yes, renew.
And you allowed him to continue. Then what does it mean?
Then Lord,
And even if an undertaking.
And clause under.
An undertaking in terror. Is it a good undertaking in eye of law?
So that's right.
It's an unequal bargain, sir. It's an unequal bargain. Between the two,
because why?
two persons, one having a full, I would say, complements of the powers and one has no powers.
There's no option but to accept to join you.
Unemployment, what? Is an unequal bargain.
Because
Give an undertaking. I will take you. You will not claim any regularization. Then why 2013 you gave a resolution? What was the necessity?
They
You
have
did not have to. Why you take out a resolution?
my only submission is the petitioners have not been appointed on open competition.
Of the human resources.
Page 113. Page 113. That is also important. Page 113, your lordship may convict. In which they have admitted we have.
Yes.
What?
Regularization of service.
Our name is next page. In which they admitted that they faced
You are recommended. You are
Yes.
recommended for regular.
and they stated that they have faced the recruitment test, where we are followed, all rules are followed, aggressive academics.
The conditionalities for all.
That is it.
fulfilled.
Yes.
So the appointing authority has said that all the conditions stipulated in 2014 clarification
Yes.
to the resolution of 2013
Yes.
is fulfilled.
Yes.
So High Court Committee has ignored such aspect and they decided against you. That is what your submission is.
It does not say that the regular, the rules relating to the filling up of the regular post was followed. No,
Three.
nothing.
Rule 3. Recruitment procedure prescribed have been followed while giving contractual engagement.
The regular posts have not been abolished. The contractual engagement has been allowed within the sanctioned strength of the post of the regular.
Clause 3. Clause 3.
So appointing authority has
They have nothing to.
Clause 3 they were.
They have nothing in place.
and we have also consistently taken that
Many
the appointing authority was to look at the time of engagement, they ought to have seen that ORP
All
has
these
been
processes.
followed, that reservation of vacancy rules have been followed. At this juncture, after explaining substantial amount of time, they cannot now result from their own.
Here they have followed. Here they have followed.
No,
You have admitted.
No.
that My friend was going.
You are standing for STA. How
yes,
can
Milord,
you,
here,
argue-
Milord,
how
Milord,
can you argue against
This
this
is the
letter?
Milord, here, Milord, appointing authority is the transport commissioner. I found out, Milord. Milord, the resolution
You
says,
stand by STS recommendations.
Milord, the resolution, Milord, the
Sir,
resolution says
cannot
the government
say
will
this.
approve the appointment. Resolution says, your lordship kindly see, the resolution dated 16/1/2014.
Say,
It was in concurrence of the finance department. When they were appointed, was their remuneration not charged with the fund? Are you not paying in concurrence of the finance department? When you are paying a remuneration, audit were not done of your department. The CAG must have done an audit. If there was any infraction, then the CAG must have pointed out that how can you give them, their appointment was irregular. This letter says that whatever the recruitment rules for filling up that regular post was followed. It also talks about the principle of reservation to be kept in mind while filling up those posts. If all those conditions are there, then 17th September regulation of 2013, that really bestowed a right in them.
Milord, that has been considered by the High Power Committee.
So for that, the court's existence is negligible because
No, Milord, that is the letter, Milord, subsequently. No, for the moment, Milord, for the moment, here the petitioner is appointed as a daily wages driver. Well, Lordship may find.
Are they not getting a remuneration?
Milord,
I am asking you, sir, are they not a contractual employees?
no.
No, show us that you have denied that they were not a contractual. Sure. Show us.
Page
Then
17.
show us that what they were paid. Every day, when they come, they are paid. Show us.
Milord,
Show us.
So, Lordship may kind see the appointment letter at page 52.
Sir, show us their payment. Sure.
Payment will
What? Are you not paying them a fixed remuneration?
yes, ma'am.
Well, what does it do? What does it?
Para 8 of your counter.
Yes, not that is fixed.
So,
Yes.
so it's not a daily rated worker. Whether they work,
Initial
they
offer.
work 10 days in a month, but they are entitled to that remuneration, monthly remuneration.
The petitioner was engaged as.
So when they become a daily rated, what is the meaning of daily rated? Means the day they will work, they will get the allowance of that day.
Yes.
If you give a fixed remuneration on a monthly basis,
Yes.
how they become a daily rated? They become a contractual influence.
Yes.
Stated so.
But that is the appointment letter also.
Yes.
So contractual and your circular of
But
17th,
here, Lord, what
circular of 17th.
the letter my learned friend relies
You
on.
are appearing for the department, but I think you know better than anybody else that what your department has done. Sometimes the bad cases are to be
So only
don't argue which is contrary to law and which is contrary to your own record. Do not argue as a sake of
Mr.
argument.
Beda, you are appealing for STA. STA has recommended favorably in that problem. Yes. High Court is there to stand up and say,
Millard,
you cannot say High Court committee directed STA has done this.
after that, Millard, the STA further recommended that their case is not coming under the contract.
Not.
Yes, Millard, that is the letter of Lordship kindly
So
see.
he cannot take
Millard,
contract.
there are several letters. In one letter, the petitioner has annexed. Subsequently, another letter has been issued to the government.
Just to stand by his own decision.
Millard, that is the letter dated 2012-2017. So, Millard, High Court Committee has taken a decision.
Sir, how can he contradict himself? This page number 113.
High power committee of whom?
Millard, the secretary, Millard, the chairman.
If you are not there, let them answer.
Yes.
If this transport department has recommended favorably, then high power committee must have some material.
Yes.
So they are answerable. How you are arguing?
Millard, in
How you are arguing that this is wrong? Your letter says that no, they are entitled. Now you say that they are not entitled. We will ask him, high power committee, what they have done. That's why you're saying, as a lawyer, you know better. Sometimes the bad cases are not to be argued further.
Yes, let the government say.
Yes, let them come. Why high power committee, why it has rejected? What was the material?
Page 88, your lordship may kindly see the part of that.
What was the material
Proceeding.
before
Your
the,
lordship may
before the
kindly
high power
findings of the committee.
Yes.
In order to take a decision on the regularization of contractual drivers, the matter was placed before the high power committee. The committee thoroughly examined all the available information and after threadbare discussion taking into the views of the GA department resolution dated 16/1/2014 came to the view that since none of the provisions of the GA department are fulfilled, the regularization order dated so and so made in respect of 4 number of drivers by the STA is to be revoked. Accordingly, proposal for regularization of rest 10 contractual drivers have also been rejected, being devoid of merit and due to non-fulfillment
Now,
of the
where is this 16/1/2014 circular?
16/1/2014 that is also referred.
Where is the circular?
Page 90. Your lordship.
90.
90.
Material. Mr. Page 113.
My lord, that-
The recommendations. See, all the conditions have been fulfilled. That is the statement of the appointing authority. You have to have material to contradict that.
Before the tribunal, my lord. That was
that
the
is why,
counter before the
my
tribunal.
lord, that is why I pray, let the high power committee decision be produced before this honorable court.
You will produce, you have to produce. You have to produce, sir.
Next will be very,
That's 6. 16/1/14 resolution.
Proceeding of
How surreptitiously the high power committee arrived at the decision. There was no opportunity which was given. There was no production of the documents. Have you seen that particular 2014 resolution? This resolution was necessitated because the government was reported that many of the department, without following the recruitment rules, without following the or adhering the reservation policies, they were abruptly appointing several persons. Even through outsourcing, they were doing it. And then the government says that in case of a regularization, the court will see. And the recommendation of the transport department was that they have followed the recruitment rules. They have followed the reservation policy.
And finance department.
In absence of anything, how a high power committee surreptitiously jumped that they are not? Why? What was the material?
Your Lordship may kindly see page 86. That is the proceedings of the high power committee meeting.
I have seen that. This is what I after reading it.
Next. Lordship, page 86, your Lordship may kindly have.
I am looking at it, 86, sir. The proceeding of 10/10/2018.
10/10/2018.
Yes,
Your Lordship may kindly see capital A.
I have seen the
14 number of contractual drivers
Correct.
were engaged by STA since 2003 and are presently working
Correct.
in the office of TC Odisha and its subordinate offices. Concurrence of the finance department was obtained during 2008 for engagement of 14 number of drivers on contractual basis. Proposal from STA is received by their letter dated so and so for their regularization. In letter dated so and so, STA have submitted proposal for regularization of 14 drivers.
Where is the satisfaction? You said this 16(1) was not followed. Where is the satisfaction?
But
why it is not followed?
That is there in my lord in the next page. Your Lordship.
Yes, sure.
Let me continue, my lord.
Yes.
In the letter dated 31/10/2016, STA have submitted proposal for regularization of 14 drivers, intimating the mandatory provision in pursuance to the GA department resolution dated so and so, and have been observed properly. And in contrary to this, in the second proposal, while letter dated so and so, have submitted proposal of 14 drivers, intimating that none of the mandatory provision have been followed in pursuance to the GA department resolution dated 16/1/2014. But at the next page, in the meantime, TC had regularized 4 number of drivers with effect from 31/8/2015, citing a letter of Commerce and Transport Department letter dated 25/4/2008. The letter speaks that the FD have concurred the proposal for contractual engagement of 14 number of drivers as guided by the FD circular dated without any precondition. There is no instruction of the government to regularize these 4 contractual drivers. Accordingly, the TC was received to review the regularization made in respect of 4 number of drivers wide DO letter dated so and so. But instead of reviewing the same as the GA department resolution dated 16/1/2014.
That is the big question.
Yes.
where here the High Power Committee said that they have not followed 16(1)(2000). Why? How that is not followed? Nothing. How is not followed? Very interesting. Suddenly jump to the conclusion. No, sir. I don't think so that it can stand in the way.
But in the counter affidavit, your lordship may kindly have a glance to para 12.
Have you filed a counter?
But a counter filed by OP3, STI.
So
State has not filed.
can you stand on their counter?
The things are very clear. Was the Transport Department, while recommending their name for regularization, indicated that they followed the recruitment rules, they followed the reservation policy? Then, if the High Power Committee thought that nothing has been followed because 16 January mandates following of the procedure,
Preconditions.
then he must indicate that what was not followed.
Yes. That was not there.
And no opportunity was given to them to produce those documents. High Power Committee did not ask for any documents because that was the recruitment you followed. Did not ask.
But the counter filed by the STF at para 12 specifically says that no recruitment procedure was followed in there.
Then are they
One of the conditional.
then why that letter was written? Have they said anything that was written without the authority?
My lord, that
We will go heavy against them. They can't be
will also will look at para
I
12.
restrain from using a very no appropriate word, but not to be uttered. How can you do? No.
If my lords may kindly have a glance to para 12 of that counter, that is at page 79. There they have specifically said
What?
that merely on the strength of long continuance, if the original appointment was not made by following the due process of selection as envisaged, they are not entitled to get the benefit of regularization. That is what they are saying.
And once they say it was, then what was the selection process?
But there was no selection. They were only appointed as.
Mr. Das, I'm sitting in driver's cases, in one of the nominations, I have observed that you followed a process of fixing a notice in your office, conspicuous place of your office. And responding to that notice, persons applied and you selected. So that is the selection process you adopted at that relevant point of time. So can you result from that statement to say that you did not follow any recruitment process?
But my submission would be
for that.
My submission would be.
Yes. You uniformly followed. What is the recruitment process for the drivers in the entire state of Odisha?
My submission would be, my lord, irrespective of the recruitment process, if somebody is appointed or engaged for that matter as a DLR also, maybe a deliberative, but if on the first date of his very appointment or engagement, he is made aware of certain conditions and nature of appointment and he accepts that.
14 has come later.
14, my lord, 14 is just a clarificatory resolution.
Not says, we are talking about that affidavit and undertaking given by.
Yes. My lord,
14 has come after this.
my lord, they were appointed in 2004. I'm sorry, 2009, which is much prior to the commencement of that 2013 and the subsequent clarificatory of 2014. Now, on the date of their appointment.
See, certain conditions have been put that the conditions cannot be held to be clarified.
Well, that condition, if your lordship may kindly have a glance to that resolution once again.
Resolution, sir. In 2014, it is a separate resolution.
No, but your lordship may kindly have a glance to that resolution. Your lordship may kindly have a glance to that resolution. For a moment, my lord. Page 90.
They cannot claim any regularization.
No, my lord. Well, this resolution, why I said it is clarificatory. As per General Administration Department resolution dated 17th September 2013, the following are the mandatory eligibility condition. So this resolution of 2014 is just a clarification, clarifying the mandatory requirement of 2013 resolution. If your lordship may kindly have a glance to page 90.
Sir, probably you could not get it.
Yes.
Have you seen 2013 resolution?
Yes, my lord.
Seen?
Yes.
Where is an impediment which will come in their favor?
My lord, your lordship may kindly have a glance to
There are two
that.
situations which say that because of the financial stress, the government may not continue with the appointment of the regular employees to a sanctioned post. Yet the government cannot overlook that the manpower is necessary to run. So they say either we will abolish so that they may not claim the scale of pay, and remuneration, fixed remuneration will be paid to them.
My lord, page 53, your lordship may kindly. That resolution, the same resolution of 2013. My lord, first paragraph I am reading.
Yes.
Contractual appointments oblique engagements are made against contractual post created with the concurrence of the finance department on abolition of corresponding regular post.
Correct.
Or contractual appointments oblique engagements made against contractual post created with the concurrence of the finance department without
Abolishing the regular post.
regular post in case of new offices or for strengthening of the existing offices, services, following the recruitment procedure prescribed for the corresponding regular post.
Correct. This is what I am saying.
Yes.
Now for a driver, if there is a regular process of recruitment is provided procedure.
Yes.
Then the question is whether they have undergone that recruitment procedure.
No.
No.
Yes.
What? That you say no, but there was no material before you, you can say no. They in their letter says, I have followed while engaging them.
Your lordship may kindly see the
recruiting and appointing authorities say both, I have done.
But the appointment order, your lordship may kindly see.
It will not be revealed from the appointment order. Appointment order does not contain any recruitment rules.
It only says person
engaged.
And this engagement has been made by the RTO. Your lordship may kindly see. Only the office order, on the basis of the office order.
Department has sanctioned the post of driver. It is not that it is not. They have not.
25.
Please come to page running page 63.
25.
This is the office of the Transport Commissioner. When they sent this recommendation to Under Secretary of the Commerce and Transport Department. Please come of 13th of October 2016.
Yes, 16.
Page 63. 31st October 2016. Please come. Have you got that?
Yes.
Please come to paragraph 3. What it says, paragraph 4. Your counterpart was bold enough. He could not say this. 3 and 4. Is it not clear?
The letter they have denied before the.
I do not know. So that's why I am saying And now come to that particular finance department's sanction.
That is it.
Finance department sanction is also given.
Yes. In para 1, they have stated so.
No, there is a document.
25/4/2008. Yes, sir.
2004
Yes.
of the finance department.
Bas.
Those there.
31/12/27. Page 47.
Page
47.
Come to page 47.
31/12/2004.
Running page 47.
Yes, this is the finance department. 2004. What it says?
Says fiscal correction of general guidelines for
Correct,
abolition
for
of
abolition.
stereotypes. 75% of the base level vacant post and filling up of the essential vacant posts, including exempted category and single posts.
Great.
The Department Commerce and Transport Department letter 25/4/2008. It is 50. Can you see? It is 50. There they have stated that yes, it has got the concurrence of the finance department.
You've seen that. That is what I'm saying.
Yes.
It has got a concurrence
Concurrence
of
of
the
the
finance department. Those fulfills the conditions of
That 16.
2013 and 2014.
14. These three conditions.
Other concurrence of finance department. And then it says the recruitment process. The recruitment they say is followed. I don't think so, sir. The Sigidar was swayed by the judgment of Uma Devi and Iloma Devi. And then without looking into those documents. $68. 5 is also the same.
Same what? Same judgment.
Huh?
Same judgment.
Common judgment.
Common judgment. My client is filed 3. I have filed for giving contract.
Correct. Done.
Lovely.
On the next one.
Item 5.
Second to the moon. Second guest to that.
Sleep don't quite honest.
Item number 6.
This is a writ appeal directed against the
judgment of the Honorable Single Judge, where a professor of physiology in a medical college had filed an application for voluntary retirement, which has been rejected. The writ application was filed. Lordship's statement come to page 23. Before I take a lordship to the impugned judgment, it's all admitted facts. Page 23. This is the application.
You were transferred to some place you did not.
No, sir, that is exactly.
Well,
that is exactly what I'm trying to.
And then you say that.
Sir,
then I am going to have a voluntary.
You can also look to performance. Page 23 is the application. The application is, sir, respected madam, I, Dr. Swanso, professor of Department of Physiology, is a teacher not a doctor, is a teacher in the medical college. I want to state I am suffering from Swanso corneal spasticity with progressive loss of vision in both eyes. This is a condition of corona with no specific medical treatment, and the only option is Swanso and doubtful pregnancy are present. I am on supportive treatment. I also had the angina attack multiple times since last 5 years. I am undergoing treatment for the same. I have been advised to take rest to reduce the stress. 2 years back, I was diagnosed as a case of PID, followed severe low backage and subsequent investigation. Madam, in my 32 years of service on the Health and Family Welfare Department, I had the opportunity to serve the people of Parliament for 4.5 years. Till now, I have discharged my duty and sincerely professional. And this was made on 24/6/2024. You also kindly see page 55, the impugned order, which was the subject matter challenge. That was the rejection order, page 55. Annexure 5 at page 55.
Yes.
Madam, your representation for voluntary retirement was also inviting a reference to the subject cited above. I am to say that government, after careful consideration, have been pleased to reject your prayer for voluntary retirement. Here, from government service and larger public interest owing to dearth of faculties in the government, medical college and hospital and PG institutional state. This was the rejection. Then let's kindly come to page 91. The pleading before the Honorable Single Judge, that is at page 91. That starts with from page 88. 89, paragraph 3. Paragraph 3 is a long paragraph. I am taking to lordship straight away. Paragraph 3 refers to Rule 42 of the Orissa pension rules, which is a provisions under the pension rules where the voluntary retirement has to be accepted or rejected. Paragraph 3. But I refer to a particular judgment that I am coming to. Second line, it is humbly submitted that judgment as cited reported in 2018-17 SCC page 578 is not applicable to the case of the petitioner, since the rule in respect of Uttar Pradesh prescribed for rejection of the voluntary retirement for administrative grounds. The similar situation also arose in another case before the Honorable High Court, and the end of case was reported in 2024 to ILR Cuttack page 260. In the said case, it has been held that there is no authority on the part of the opposite party to reject the application for voluntary retirement on the ground of shortage of the dearth of doctors. Similar also in WPC number 241, a group number of cases, series cases, 24173 of 2021. This Honorable Court has also passed the order dated so and so in respect of rejection of voluntary retirement applications which is in the said case. That is, and another paragraph I will show your lordship because I will take your lordships to the impugned before taking the your lordship to the impugned order. Page 94, paragraph 6. This is my specific reading. That in reply to the averment made in paragraph 10 of the counter affidavit, it is submitted that the same is not correct and allegation as labeled in the said paragraph against the petitioner is hereby denied. The petitioner has submitted the relevant document and prescription relating to her prolonged illness. She has been able to work at Barampur since the family support is there, but now the petitioner is not in a position to work due to her vision problem as well as other diseases. The petitioner is also now not mentally and physically fit to perform the duties perfectly. For the said reason, the petitioner has submitted her application for voluntary retirement. It is not out of place to mention here that petitioner has appeared before the medical board and also the leave has been granted thereafter
As per the advice of the medical board, the illness of the petitioner has also been confirmed by the medical board. So the rejection of the petitioner's application is not tenable in the eye of law. Paragraph 96, I have said that the opposite party have considered application of other on the same ground, and they have also granted the voluntary retirement. Then you also kindly come to page 96, page 99. Page 99, right from page 99, you also see that kindly come to page 99. Yes. So, on 10/7/2024, the Chief District Medical Officer referred my case to the Additional Secretary to Government for medical examination, and the medical examination also see that the standing second paragraph with reference to the subject cited above, I am to inform to you, Dr. So-and-so petitioner, Professor so-and-so has appeared before the Standing Medical Board on 3/7/2024 along with all treatment records in connection with her ill health as she is continuing her leave from 1/3/2024. The Standing Medical Board examined her and considering her present health condition, the board advised bed rest for 2 months and directed to attend the next medical board on 3/9/2024. I am enclosing herewith a copy of the proceeding of the Standing Medical Board dated so-and-so. Page 100 also, that is on 12/7/2024 extension, that is before the medical board also, they appeared again. Then 101, 102, 103, all even consequently, let us also kindly come to page 101 on 6/12/2024, she appeared before the medical board, and the medical board also again said the Standing Medical Board examined her and allowed further 1 month rest considering the present health condition and directed to attend the medical board on 3/1/2005. Then continuously, every month and every alternative month, she's appearing before the medical board and medical board that she's not fit. Now, she's till that she's on leave. You'll also then kindly come to the additional affidavit I have filed, which you also have already got on record. That additional affidavit, that is to substantiate my pleadings in the before the honorable single judge. Also, just kindly have a glance to that, because the only ground on which it has been my application has been rejected, not on health ground, but they have developed it saying that subsequently because of transfer and all these things they have said so. But the ground they have rejected, the dot of doctors. Even also we look to Annexure 10 at page 7. The Annexure 10 page Flag C. Also see this order has been passed by Government of Orissa Health and Family Welfare Department on 12/10/2023. After careful consideration, government have been pleased to allow Dr. So-and-so, head of the Department of Physiology, my department, to retire voluntarily from the government service on personal ground with effect from the date of issue of this order in terms of Rule 42. Then you are also going to come to the next page, page 9. On 27/12/2024, my order was passed on 17/9/2024. On 27/12/2024, you also see the Government of Orissa Health Department, after careful consideration of representation of Dr. Santosh Kumar Rautray, senior consultant, he's a doctor. So far as physiology is concerned, that is at page 7, my department. But a doctor, his application for the voluntary retirement, government have been pleased to allow Dr. Santosh Kumar Rautray to retire voluntarily from government service on health ground in pursuance to Rule 42 of with immediate effect. Then if you also will look to page 10, the recent, on 11/3/2025, the petitioner was asked to appear before the medical board, and the medical board again, also look to page 10. I'm reading it. Sir, this is a letter from the Chief District Medical Officer to the Additional Secretary to Government Health and Family Welfare. Sir, with reference to the subject cited above, and to inform you that Dr. Signaprabha Misra, Professor of so-and-so, has again appeared before the Standing Medical Board on 3/3/2025 along with all treatment records in connection with her ill health. The Standing Medical Board examined her. Sir. Because this has not been Rule 42. Yes. That has been interpreted by.
These documents are not before the,
It is there. These all the documents are there.
No, this, flat C.
Yes, Flag C affidavit is a subsequent medical report, but the earlier medical report till disposal, all were enclosed to the gender and that was placed before you.
It's a really, I would say, the depletion of the earlier one.
Yes. What's the line? Now, my point of before worship is this. You also look to the Rule 42, which has not been taken note of by the Honorable Single Judge, though a coordinate bench interpreting Rule 42 of our Orissa pension rules has come to a conclusion, and so that judgment, whether that coordinate bench is correct or not, that your lordship knows that so far another bench, earlier judgment is there on the interpretation of that particular rule. Either he has to accept it or he has to refer to a division bench. But the Honorable Single Judge has not at all considered that aspect and so from the judgment. Also, kindly look to Rule 42, what it says, because it stands little bit different than the rule of West Bengal as well as also to Uttar Pradesh. Because I had occasion to go through a judgment of my Lord Justice Tandon, where also you also sorry, that judgment.
Now that becomes the judgment of this court. Because of
yes,
I want those judgments with
That was a case of a different nature.
Yes, sir, I've gone through.
There are several doctors
Yes.
who were there in the state role.
Right, sir.
They got a better prospects in the
other
resignation.
That's
The resignation was rejected by the sub-government, saying that
you know, sure, remember that.
health sector exigencies and there is a dearth of doctors.
Doctor, yes. And rule is otherwise also. Suppose West Bengal rule is otherwise. That's so that. That's thinking. Yes. I am concerned. You also look to Rule 42. I think. Voluntary retirement on completion of 20 years. Let's get it. Orissa pension rules.
Yes, as it says that the right is given.
Yes. So
3 months notice.
Yes. Then kindly come to the note. It has been interpreted by the single judge. I am giving the copy of the judge. Note. Sir, I am reading it again. At any time after the government servant has completed 20 years qualifying service, he may, by giving notice of not less than 3 months in writing to the appointing authority retired from service. 2. The notice of voluntary retirement given under sub-rule 1 shall require acceptance by the appointing authority. Then note, such acceptance may be generally given in all cases except those A, in which disciplinary proceedings are pending or contemplated against the government servant concerned for the imposition of a major penalty, and the disciplinary authority having regard to the circumstances of the case is of the view that the imposition of penalty or removal of dismissal from service will be warranted in the case. Then B, in which prosecution is contemplated or have launched in a court of law against the government servant concerned, if it is proposed to accept the notice of voluntary retirement, in such cases, approval of the government should be obtained, provided that where the appointing authority does not refuse to grant the permission for retirement before the expiry of the period specified in the said notice, the retirement shall become effective from the date of expiry of the said period. So I am giving emphasize such acceptance may be generally given in all cases except those A and B. You also look to the judgment of the Honorable, of course, a single judge, which was before the Honorable. I have specifically submitted this judgment also before the Honorable Single Judge, and that was also part of the pleadings. You also look to this. Sir, kindly come to paragraph 9. This was cited in the rejoinder. I placed before Lordship 2018. 2024 ILR. Para 9. Lordship, look to paragraph 9. Incidentally, I was also counsel there. Of course, this judgment has been followed in many cases subsequently. I will show you, Lordship. Mr. Rauta, Senior Counsel, appearing for the petition, para 9. At the outset, submitted that the grounds taken in the rejection are untenable in the eye of law. He further contended that the application seeking voluntary retirement from service is governed by the provisions contained in Rule 42 of the Orissa Pension Rules 1992. Further referring to Rule 42(1), the Senior Counsel submitted that the government servant acquires eligibility to make an application before the government seeking voluntary retirement from service after completion of 20 years of qualifying service. So far as the present petitioner is concerned, it was submitted before this court that he has rendered more than 26 years of unblemished service to the public as a doctor in various medical colleges of the state. Therefore, the petitioner is eligible to make an application seeking voluntary retirement from service. By referring to Rule 42, London Senior Counsel for the petitioner further contended that the only eligibility criteria for being eligible to submit an application seeking voluntary retirement is the qualifying service of 20 years by government servant seeking VRS. It was also contended that government servant who is seeking voluntary retirement from service is required to give a notice to the government public appointing authority of not less than 3 months in writing. Additionally, it was submitted that Rule 42(2) provides that notice of voluntary retirement given under Sub-Rule 1 shall require acceptance by the appointing authority. Then, sir, kindly come to paragraph 11. Next page. London Senior Counsel appearing for the petitioner has laid much emphasis on the note appended to Rule 42(2). Therefore, this court feels that the aforesaid note requires a thorough scrutiny by this court, and the same is quoted hereunder. I need not repeat because I have already placed with the worship. Then paragraph 12. Upon a cursory look at the note appended to Rule 42(2), this court observed that it has been specifically provided that the acceptance of under Rule 42(2) may be generally given in all cases except in the following cases. A, in which disciplinary proceedings are pending or contemplated. Let's skip over. B, in the prosecution is contemplated or have been launched in a court of law against the government servant concerned. Then para 13. A conjoint reading of Sub-Rule 1 of Sub-Rule 2 of Rule 42 as well as the note appended to Sub-Rule 2 clearly provides that a government servant on completion of 20 years of qualifying service become eligible to apply for voluntary retirement from service. However, such government servant has to give a notice not less than 3 months in writing to the appointing authority. Furthermore, the notice given by the government servant requires acceptance by the appointing authority under Sub-Rule 2. The note appended to Sub-Rule 2, although may not override the substantive provision contained in Sub-Rule 2, however, the same is indicative in nature. Such note clearly provides that the acceptance contemplated under Sub-Rule 2 may be given generally in all cases. That is, acceptance of VRS is a rule and the rejection is an exception. Additionally, certain exceptions under which the VRS application may be refused have also been indicated in the note appended to Sub-Rule 2. Ergo, while considering the case of the petitioner, the court is required to examine the case of the petitioner by applying the aforesaid analysis of law and the provisions contained in Rule 42 of the OCS Pension Rule 92. Then kindly come to paragraph 17. What the argument was advanced by the State Council. Para 17. The learned additional government advocate, on the other hand, filed a copy of the PwC of the OP number 1 along with a cover letter. By referring to the above noted PwC, the learned additional government advocate submitted that petitioner submitted his VRS application on 15/2/2024 on the ground that he has to take care of his family owing to the ground of illness of his mother and wife. The PwC further revealed that the opposite party number 1, after careful examination of the application, has been pleased to reject the same on the ground of acute shortage of faculties in the government medical college and hospital in the state. They have also cited that due to such acute shortage of faculties, the government of Orissa Health and Family Welfare Department is unable to meet the minimum standard requirement as prescribed by the National Medical Commission of the Government Medical College. Since the VRS application is based on the personal ground, the OP number 1 has rejected the same by proclaiming that the personal inconvenience of the government servant is not a larger public interest involved in not accepting such VRS. Then, sir, paragraph 19 is the conclusion. On a careful reading of the PwC submitted before the court by the learned additional government advocate, this court is of the observation that opposite parties have emphasized the public interest involved in not accepting the VRS application in different paragraphs of the PwC. On a careful reading of PwC, this court found that in sum and substance, the PwC depicts that the decision taken by the committee do not accept the application of the petitioner seeking voluntary retirement is based on the ground of acute shortage of faculties in the state and the duty of the government to fulfill the minimum prescribed standards requirement of National Medical Commission. Then para 20. In course of argument, the learned additional government advocate referred to the judgment of the Honorable Supreme Court in the state of Uttar Pradesh versus Achal Singh, reported in 2018, 17 SCC, volume 17 SCC 578. In course of argument, the additional government advocate places specific reference to paragraph 36, 37, 41, 42, and 43 of the judgment. By referring to the above noted judgment, the Honorable Supreme Court additional government advocate submitted that in the identical cases referred to above of the state of Uttar Pradesh, the government declined to accept the voluntary retirement application of the doctor on the ground of public interest, and the Honorable Supreme Court has upheld the decision of the state and has specifically held that it cannot be said that the state has committed an illegality or its decision suffered from any arbitrariness. By referring to the aforesaid judgment, Lawrence additional government advocate further contended that the government servant right to retire under Part 3 of the Constitution cannot be placed higher than the supreme right under the Constitution, that is the right to life of the citizen residing in the state. He further contended that right of government servant is to be interpreted along with the right of the state government under Part 4 of the Constitution. Further, they specifically referred to Article 47 and in Part 4 of the Constitution to emphasize that the government has to make an endeavor under the said article to look after the provisions of the raising the level of health and nutrition of the people in the state. It was argued that the right enshrined under Article 19(1) is subject to the interest of the general public. Thus, such right can only be exercised as per the rule and not otherwise. Furthermore, referring to paragraph 41 of the said judgment, an additional government advocate submitted that since there is scarcity of doctors in the state, the petitioner cannot resort to the ground of claiming equality with other similarly placed doctors whose application for voluntary retirement have been approved by the state in the recent past. It was also argued there is no concept of negative equality in law, especially against the larger interest of the public, and in case such a plea is allowed, none may be left to serve in the public large. On the aforesaid grounds, an additional government advocate contended that the prayer of the petitioner seeking voluntary retirement from government service is not unsustainable law, and the opposite party have not committed any illegality in rejecting the prayer of the petitioner for voluntary retirement from service. In such view of the matter, the learned additional government advocate submitted the present writ application is devoid of any merit and accordingly sent to be dismissed. Then para 21 is the ultimate finding. Having regard to the submissions made by Lord Senior Counsel for the petitioner as well as the Lord Additional Government Advocate on a careful scrutiny of the materials placed before the court, it is observed that this court required to examine the impugned rejection order in the light of the provision contained in 42 of the Orissa Pension Law. So far, factual matrix involved in the present case application is concerned, that the date of joining of the petitioner, number of years of service rendered by the petitioner, etc., the same is not
Yes, yes.
Yes, sir. I was reading para 21. In the light of the provisions contained in Rule 42 of the Orissa Pension Rule 1992. So far, the factual matrix involved in the present application is concerned, the date of joining of the petitioner, the number of years of service rendered by the petitioner, etc., the same is not disputed by either side. Why? While
I think paragraph 26.
Yes, sir. Yes,
We have already completed it.
you are not sure. I've already completed. I'm sorry. So on this,
So the 26 is there.
Yes.
That what is the effect of the node being appended?
right. That's right. Now you also look to the impugned judgment. This judgment
Also
has
my own judgment over there is also on this.
yes.
When the statutory provisions contain a note or
Yes.
an explanation
Yes.
appended thereto, this is a subordinate specification.
Yes, sir.
Then note becomes a part of the structure. You cannot
Subsequent difference. Yes. Sir. And the subsequent judgments also, I need not cite same point on 42 has been interpreted. Other coordinate benches have also followed and they have also.
State is following that goes against the state. No, this is not a judgment.
Yes, that is not a judgment, that is an order.
This is
But
not.
rendered by your also
And
in Calcutta. Para 4, my lord.
that judgment I have brought it. That's 7588.
That is a different judgment. This is relation, but with regard to the resignation.
Here it is not the
case where in a health engineering department, or sorry, PHE, or the Public Health and Engineering Department, the cadre was sought to be changed. Then the rules, they contain certain notes that how it is to be done.
Yes, I understand.
Then the argument was advanced that note does not carry any force in eye of law, because this is the note which is appended, not the substantive or enabling provision. Then says the note becomes a part of this study.
And my respective submission, Lordship, the impugned judgment of the Honorable Single Judge has never referred to even Rule 42. What to about this judgment? Judgment has not been referred to. Rule has not been referred to. My respective submission before Lordship is, if suppose there is a judgment of a coordinate bench, even if that judgment is a wrong, Lordship, I need not repeat those arguments. So either that is binding on the single judge or it has to be referred to a division bench. And if you also look to the impugned judgment, instead of referring to Rule 42, the Honorable Single Judge, with all humility, at paragraph 21, has given an advice to the state to look to paragraph 21. In fact,
Yes.
Para 21 and 22. Hence,
125.
page 125, only page 125.
Yes.
Hence, where the legislature has not spoken, where the executive has not acted, the duty falls upon the court to lay down the gavel with certainty, to step into the breach and to ensure that justice doesn't
Strike the gavel or lay down
strike
the
the
gavel.
gavel. Yes. Then recognize the indispensable role of physicians of safeguarding the public health and the
Purpose of the gavel is to stop. Nothing. Yes, anyhow, sorry.
So, para 22, and this is the ultimately the following broad policy recommendation for the government consideration in drafting a framework for the retention of doctors within the healthcare system. A, B, C, D, like this they have been given. But 42 has not been taken into consideration. The judgment of the coordinate bench, 2-3 judgment have been those cited, it was not referred to, and the ultimately it has and the medical ground I have given, that has also not been taken into consideration. That is my specific case. For last 1 year, I have been 1.5 years, every month, the medical board, I have been examined by the medical board, and medical board has given the opinion that has been accepted and leave has been granted. Till today. And I am not a doctor in the field. I am a teacher in a, and the very same, and I have already shown to your Lordship at page 9. In my department, the head of the department, he has resigned and his voluntary retirement has been accepted.
Here two instances.
Right.
One is,
Yes.
one is of your department of 2023,
Sir.
and one of 2025.
2025, sir.
Is a different department.
Yes.
And you are also a professor in
Physiology, same department, in page 9, the same department.
My lord, your lordship may kindly come to page
The
73.
other judgment I did not cite before, Lordship, that if a coordinate bench has delivered a judgment that is either binding or to be recorded division bench, I have brought it here. Para 35 and 36. 2021, 12 SCC, page 1. Last but one page, para 35.
Yes.
The learned single judge in the impugned judgment has taken a contrary view to the earlier judgment of the learned single judge in so-and-so case. It is well settled that a coordinate bench cannot take a contrary view, and in the event there was any doubt, a coordinate bench only can refer the matter for consideration by a larger bench.
That is a different issue. That was in relation to a criminal case.
That is that. But there are other judgments I can cite also.
Between the Sanjay Das case, the Navjot Singh Sidhu's case, and those cases where the default bail.
Yes. But that is the
If
issue.
an application is not filed within the period when the default has a isn't.
Yes.
Then keep up. This Kasi's judgment is on that.
That what your lordship kindly referred to that very paragraph, the judgment which I referred to and I quoted that Punjab versus Devas modern breweries, paragraph 339, judicial discipline. Judicially discipline and
No difficulty.
Your lordship, I need not place it.
The principles of the committee and the committee of the judicial discipline demands the adherence of the coordinate based decisions.
Yes.
Any departure or a dissent refer the matter to
Larger.
justice to constitute a larger.
Actually.
Well, here actually we were discussing on a different aspect. All the documents appended to the petition about the medical certificates, all are pertaining to prior to the order of transfer. If she was ailing,
Subsequently, she has
subsequent also,
medical.
subsequent also.
So
I don't
the
think
medical board has suggested
there is
that
no
she is suffering. And when the medical board says that review after 1 month, review, and it's a continuous process.
Possibly,
Then in that event, what wrong?
my intention was to my endeavor was to persuade your lordship to come to this extent that she was transferred.
My initial
Much prior to that, she was suffering. As per the
initial my
documents.
impression was that she was transferred. She made a representation.
That what
was
is-
not very much interested in going there. The moment the authority said no, you should go there, started resigning.
That
and
what
seeking
your
our
lordship find on page 73.
But that does not appear to be so now.
That is there, 73 page, your lordship.
That is a fact, but it does not now appear. Subsequent, there-
Subsequent events.
there has been.
But if your lordship comes to page 73, your lordship will possibly accept my in that only after the sorry, ma'am.
Different medical boards have.
Yes, that cannot be any dispute about that. Now, we had 3 medical colleges in Odisha. Now your lordship knows it is more than 50. So we must have to send the teachers for teaching. Physiology is a non-clinical subject. Teaching is important. That is how doctors are to be transferred. Because 3 medical colleges, now we are more than 15 medical colleges. Dearth of teachers. That is how they are being sorted out. They are being transferred. Now taking the plea of health, if she was in a position to
You have
continue.
allowed one of the doctor of the same department, physiology.
The reason has not been given. One man.
Whatever you have allowed, that means the dearth of a qualified teacher in the subject, that is ruled out.
I understand.
Health ground.
Sorry, health ground. Health ground. Somebody may
Here also health ground.
somebody may be having some brain problem and somebody may be having some eye problem.
Maybe.
Brain problem, teacher cannot teach.
Even an eye problem, if he does not read, then how he will teach.
The other philosopher, physiology man, who has been allowed to go on voluntary retirement, possibly he may be having some bigger disease. That has not been reflected in that one.
Because physiology needs constant reading. If you are not updated, then how you will teach the student?
Now, on the question of Rule 42, note, may I read once again? Voluntary retirement on completion of 20 years qualifying service. At any time after government servant has completed 20 years qualifying service, he may, by giving notice of not less than 3 months, in writing to the appointing authority, retire from service. So, the notice of voluntary retirement given under Sub-Rule 1 shall require acceptance by the appointing authority. 2 requirements, 20 years of completion of service, 3 months notice. And Sub-Rule 2, it requires acceptance by the government. Appointing authority. Here, I think the cross line. It is to be accepted by the appointing authority. Now, note, if it is not accepted, then it requires the action of government. Note, may I read once again the note. Such acceptance may be generally given in all cases except those A, in which disciplinary proceedings are pending or contemplated
It is not a
government
case here.
servant. Sorry,
It is not a case here.
it is not a case here.
B.
B, in which prosecution is contemplated to have launched a
That
court
is
of law.
also
It is
not
not
a case here.
a
Any
case also
case
there.
has not been launched.
Yes, in these 2 contingencies, it doesn't arise here.
So,
If it is proper to accept the notice, in that event, the voluntary approval of the government should be obtained.
okay, correct.
So, note
who is my non-senior was placing, I am trying to persuade your lordship that first acceptance is to be taken by the appointing authority. To 20 years of service, 3 months notice. That acceptance is to be given by the appointing authority. But note says, what I intend to say, Madam, this note relates to situations where contemplation of disciplinary proceeding.
No, the first line and the second line has to be dissected. The first line of the note says that in all the situations when a person has applied for voluntary retirement, it has to be granted generally.
General.
Exception then carved out too, that in such an event, the approval of the government is
required. We are not.
He is saying that a general proposition that it has to be granted generally, you should grant it generally unless there is a very exceptional case that would come. Would be granted generally does not mean that every application to be granted. But not very technical ground, you should not reject. Unless there is a very incriminating materials which have come. Or definitely the administrative exigencies.
Yes.
No doubt, say health sector.
My entire endeavor was to persuade your lordship to consider this aspect only, that this note pertains to two situations, contemplation of proceeding. In that case, government's approval is required. Note says that.
Read it.
Such cases.
Such acceptance.
Yes.
Acceptance of voluntary
acceptance means what?
Of voluntary
Notice of voluntary requirement shall require acceptance by the appointing authority.
Yes.
So acceptance means acceptance by the appointing authority.
Yes.
Maybe generally give
in all
cases, except then an exception is carved.
It starts.
So it contemplates too that in any situation which does not come within the exception, it should be granted generally.
Yes. Yes.
Only in case of an exception. Then the government's permission or approval is required.
But those exceptions have been carved out here. That contemplation, A, B, two situations have been there.
So under they are the special circumstances.
These are the special exceptions.
Yes. On these two contingencies.
Sometimes it is general.
On these
So
two
let us
contingencies.
say to No. Just wait. Twice he was, where are the documents? Twice she was examined.
That's a rejoinder, Your Honor. That is Annexure 8, starts with page number 99.
Annexure
8, Your Lordship. Starts with page number 99.
Oh. Yes.
Page 99 says.
Yes.
Give me the.
Yes.
With all the rejoinders.
Yes.
Sit.
Yes.
Fine.
Item number 7.
It's a very small case, my lord. That
consuming lot of time.
that's why I'm saying it's very small case, only 2 days. My lord, the appellant is a Anganwadi worker selected, meritorious, and he married in the month of May of 2016 to the village where you are selected as Anganwadi worker.
He or she.
She, my lord, all are Anganwadi worker.
That is why I
Sorry.
said he, I was surprised enough.
Sorry, my lord. So that's the translation. I have come up with the translation of the.
No, very meritorious lady. And then working as an Anganwadi or not working as an Anganwadi?
Working as Anganwadi.
Correct. Then she got married.
No. First, she got married to that village. Then Anganwadi advertisement.
Married in the village.
Married in the village. Then Anganwadi advertisement
Application was made. Then she applied.
Then she applied, my lord.
No difficulty then.
Then, my lord, there was in the advertisement, there was a last date of submission of application was 7/7/2016. But 7/7/2016 was a holiday, declared holiday. When it was detected by the CDPO, the last date of submission of application was a holiday. So he asked the chairman of the committee, that is sub-collector, selection committee. Sub-collector on 30th June directed the verification of documents will happen on 12th July. Because there is lot of holidays in between and only one working day, that is 11/7, that has been skipped by the sub-collector. That not doing it on 11/7/2016, which was a working day, they have done it on 12/7/2016. And I got selected. And now the honorable, this court, that they cannot do it on 12th July. They had to do it on 11th July. That's why my selection was being negated.
No. This was extended till 11th of July.
No. That was on 8th. 8th was the working day. That's the last date of submission of the application. 9th, 10th is holiday.
Correct.
The second Saturday and Sunday.
Correct.
Then 11th is a Monday. That is a working day.
Correct.
And that on that day, the chairman selection committee.
So there is no time limit given that.
16th day will be the verification date. There is no rule and regulation, only by circulars this Anganwadi appointments made by. On 16th day, that will be verified. The documents will be verified. And on 16th day, it was a holiday. That's why it is on the 12th. But in between that, 11th July is a working day.
No, I understand. Suppose if the scrutiny or the verification is done beyond the 16th day.
16th day.
Then is there this circular?
Yes, sir.
My lord, there is the advertisement. That is the English translation of the only advertisement for your lordship because it is in vernacular.
Instead of 16th to 15th day.
No. The 17th day.
17th day.
That's the my case, my lord. That your lordship kindly see one. My lord, Annex 1, phase 18. That last date of submission application is 7/7. And that 7/7 is a holiday. That's why it was extended to 8/7.
Yes.
My lord. And when it was detected by the CDPO, the 7/7 was a public holiday. My lord, kindly have a glance to 57. That is filed before the Honorable Single Bench that
So it was said that on 7/7 will be
last date of submission of application.
And on 8/7
is the
verification.
But 8/7 is the last date of application because 7/7 is a
So
holiday.
where do I get it, the extension?
My lord, that is page 56 of the brief, my lord.
Of the?
My lord, read appeal, page 56.
Yes.
My lord, that is the note, the committee by the executive in prior hand to this for fixing.
No.
I am reading, my lord. As on 7/7/2016.
Page
56, my lord.
It's actually reading from the fourth line.
Fourth line.
56.
56.
As per the above guideline, the verification and certificates were scheduled on
16 day, that is on 7/7, as 7/7/6 falls as a holiday, and file was submitted to Sub-Collector Puri cum Chairman of the committee by ex-CDPO in prior hand on 36/2016
for fixing a suitable date for verification of application and certificate filed by the applicant. Therefore, thereafter, on 9/7/2016 and 10/7/2016 were government holidays as revealed from record. The sub-collector Puri, by this kind order dated 30/6/2016, fixed the verification program on 12/7/2016. My lord, point is here, there's no malafide is attributed that why it is been
No,
posted.
where is this 15-day concept, 16-day concept? It was, there's a authority thought that it should be fixed on a 15th day or a 16th day. There is no statutory.
Statutory no.
There are guidelines issued to that.
Guidelines.
There are
Where
guidelines.
are the guidelines? I just wanted to know that.
That's the
Where
guideline.
are the guidelines?
There are two things, Your Lordship, I need to point out.
My lord,
Start from page 29, guidelines for Anganwadi workers.
Yes,
Dated
we
to
had some across today at 17th delivered
Okay.
judgment anyhow. So what it says?
Page 31 says the procedures.
Yes.
C, B and C. B says 15 days time will be given to the candidate to apply to the CDPO along with the documents in support of the nativity, educational qualification, caste and any other. C says on the 16th day, the CDPO will verify the documents of the applicants in their presence and will notify the name of the applicants in her office notice board and at the village, GP and Panchayat Samiti level. In case 16th day is a holiday, then verification and notification of the applicants will be done on the next working day.
Yes.
I want to draw your lordship's kind attention that, my lord, that the translation copy I have given in advertisement. Advertisement says 8/7/2016 is the date for verification of the documents. 8/7. My lord, kindly see page 19. That is the mistake done by my lord. 8/7/2016 is the date of verification of documents. That is the 16th day. But when 7/7 falls as a holiday, then the last date of submission application is 8/7/2016. 9 is the second Saturday, 10th is the Sunday, and 11th is the only working day. That's why sub-collector on 30th June, my lord, that note sheet also they have filed, the government filed before this honorable court, stated that as 8, 9 and 10 is holiday, I will verification will be done on 12. And accordingly, I am selected, my lord, being the highest.
And he is unselected.
I am unselected. I have approached the.
My lord, exactly.
Number 2 in the panel.
Yes, sir.
That's.
I have 2 points to make.
My lord,
Number 2 in the panel.
Number 2.
I am, my lord. That's exactly in the same case, my lord. The single judge and the same ADM, my lord. He has stated that. This is a
11th was not available.
my lord.
No.
11th July was no.
It was a working day. But what I gathered information that although I have applied under RTI, I could not, the sub-collector was on leave. That's why he kept on 12. My lord, in the same similar type of case, the Honorable Single Judge says this is a super hyper technical approach. That only because of the one day is that because
In this case, he has not taken a super hypothetical.
I'll tell you, Lordship.
that's
Just 2 points.
why I'm before your lordship. My lord, that another case.
Something.
Yes, Your Lordship. Your Lordship, procedure B says.
But I find from the judgment, I say much appreciate that she has placed the case in a such a manner that really swayed the bench.
No, only is correct. But her candidature was rejected on the ground that her application was not completed on the last date of submission of application. That is the reason I find from the Honorable Chingliker also took note of that. For 13 at page 66. Two things emerge from the above analysis. One, the petitioner's application was incomplete in the absence of a residential certificate. That is the reason.
Recently married.
That I'm drawing your lordship's attention.
Recently married.
Recently married and applied.
20 days before.
Just within a month, my lord, I am married in May. That is in June. My lord, kindly see, I have given my card, my lord. My lord, kindly see that advertisement, the English translated.
Card.
Invitation card when I got married. That is the date is there. My lord,
It was given to who?
filed before this honorable court. Filed before this honorable court.
Is only for the purpose of using it in the court or given it to many?
Well, for a moment, my lord, kindly appreciate in the translated copy I have given, everything is to submit, but nativity certificate is now here to be submitted along with the application. That is the advertisement. My lord, kindly see. Applicant must be permanent resident of within the village of Muttal. My lord, kindly see that. Kindly see that advertisement. Everything is, my lord, in Odia also there. That is to be submitted. To be
I
submitted.
can understand if you read it.
Odia.
You can't read it. You can read it, I can understand.
My lord, obliged, my lord.
Yes, read it.
That Partini Anganwadi Kendra Antarbhukta Grama Poda Grama.
Slowly.
Partini Anganwadi Kendra Antarbhukta Grama Poda O Grammar Stai Basinda Hoithibe.
Means Poda means must have studied in the school.
Poda means that lane. That from which home to from which home that this lane is.
And must be sthai means
Permanent. Hoithibe. But there is nowhere stated in the advertisement you have to submit the nativity certificate along with the application. And in other condition, हरिजन आदिवासी होइथिले जातिगत प्रमाणपत्रर नकल दाखल करिवे कास्ट सर्टिफिकेट
if you belong to a reserved category then you'll have to give a certificate then
पार्थिनी मानकर शिक्षागत योग्यता अति कम रे मैट्रिक किंबा तदुर्थ होइथिबो एथि सहित मैट्रिक सर्टिफिकेट और मैट्रिक प्राप्त नंबर सह नकल दाखल करिवे
correct so she must be at least a matriculation
that should be submitted
and on the basis of the marks obtained merit would be
मातृहीना निराश्रय बालिका होइथिले संपृक्त संस्थार सर्टिफिकेट रे नकल दाखल करिवे इफ यू आर ऑर्फन एंड देन यू हैव टू सबमिट शारीरिक अक्षम होइथिले अक्षम सर्टिफिकेट रो नकल सह एक संपृक्त फोटो
physically disabled certificate is to be given
physically lordship is understanding Russia स्वामी परित्यक्ता
so what do you think
स्वामी परित्यक्ता होइथिले ताहार प्रमाण पत्र
you are divorced or you are thrown out by your husband
उच्च शिक्षा हासिल करिथिले जथा +2 +3 सर्टिफिकेट रो नकल दाखल करिवे संपृक्त अंगनवाड़ी केंद्र पई प्रार्थीनी माने ईसीसी रो कर्मी होइथिले डीपीसी को ठारू सर्टिफिकेट आनी दाखल करिवे समस्त प्रमाण पत्र नकल गेजेटेड ऑफिसर को ठारू अटेस्टेड करि देबे
attestation has to be done by a gazetted officer
एंड 2 कोटी पासपोर्ट साइज रो फोटो दाखल करिवे
बस 2 passport size photo of a recent origin or old
5 टंका पोस्टल स्टैंप लागि थिबा गोटे निज नाम
postal stamp
along with निज नाम ठिकाना लेखा थिबा लफाफा दाखल करी
self attested envelope so that they will send 5 rupees
माइलर संपृक्त केंद्रर प्रार्थीनी बालबाड़ी कर्मी भाबे काम करूथुले ताहार प्रमाण पत्र सहित उपरिस्थ कर्मकर्ता
is working as a balkarmi
then that is to be submitted but everything has to be submitted along with the application
so
but
not a resident
not a resident certificate if you are not belong to that residence you can raise objection if somebody
understood
my lord that's we are obliged my lord you understand my lord my point is that on 8/7 is the
yes if it is not mandatory then
no it is
if I come to I can take your lordship to the procedure.
Recently married, if she has gone there, then she will be.
Your lordship, there's a division bench judgment of
The
this High
office
Court.
will record it. The panchayat
There is
will
a
also
division bench
record
judgment
their
of this
names.
High Court, your lordship, squarely covering this. I will first take you to the procedures, your lordship.
If you deny that she is not married.
No, I'm not denying that.
The marriage center, the marriage invitation card is a fake one.
That is not. No, that I am not alleging. The documents, the procedure, your lordship, may kindly see B. 15 days.
Or I can appreciate it that her husband has.
No, that is not my case.
Gone to her parents.
That is not
house
my case. I am only on the procedure, that the procedure has to be followed. Procedure says 15 days time will be given to the candidates to apply to the CDPO along with the documents in support of nativity, educational qualification, caste and others. The procedure should be the one I was showing you. Page 31.
This advertisement does not indicate.
But the advertisement is based on the procedure.
No,
it is from the guidelines.
You have to show it.
You have
to show it. It is indicated that all application must conform to the guidelines which are issued by the government.
I will take you to a division bench judgment.
Appreciate it.
There's a division bench judgment.
And if she decides and gives subsequently, you get.
Yes. On last date of verification, I have produced my.
On the last date of for last date fixed for filing of the application, the residence certificate was not there. It was issued on 11th. The last date was 7th or 8th, whatever your lordship may deem fit.
Subsequently, she has submitted.
Yes. And may I kindly see the
She submitted on the date of verification.
Yes. And I have given
the date of verification which was deferred wrongly, 17th day.
That is the difference.
Your lordship may kindly see the last page. There's two different copies I have given. I'm sorry for that. Non-filing of the certificate along with the application pursuant to condition 1 of annexure 1 has rendered the application invalid. Therefore, the application of the appellant could have been rejected by the respondent number 4 for non-production of residence certificate. Since the requirement was that the application should be a permanent resident of the concerned village, Anganwadi area, non-production of residence certificate to prove permanent residentship is itself a ground for rejection of the application on the ground that it is not a valid application. Appellant selection on the basis of the mark secured is illegal. The same could have been interfered with by respondent number 3 in exercise of the appellate jurisdiction while examining the correctness of the order of the Tahsildar stating that she has given undertaking that the residence certificate will be produced. So giving the undertaking is not allowed. To prove the nativity, residence certificate has to be given along with the application. Therefore, the learned single judge has rightly made observation that the appellant was required to adhere to the guidelines enumerated under the scheme, that the applicant should furnish the residence certificate. If the same is not produced, the application is not a legally valid one, and the same is treated as no application of the law. Such observation is in conformity with the well-settled principles of law, held in Supreme Court, so and so. And further, the learned single judge has rightly caused the impugned order to respond number 3 and allowed the writ petition. This is a division bench judgment of this High Court. The guidelines had to be adhered to. The guidelines say that submission of the residence certificate along with the application is valid.
No difficulty, we'll say, and we don't think so there was any case which is decided on them, which you are aware.
That was a similar fact, Lordship. This girl
No,
in
the
that
fact
case was also
was
married
that
to.
as it appears, there is some kind of a, I think, confusion that has come.
Mhm.
It simply talks about that there was an advertisement and probably the advertisement postulates the annexation of the residential zone.
No, Your Lordship, it says the
It is
advertisement
that
has to
paragraph
be.
one of the guidelines.
Yes, Your Lordship.
Relating to, I find that there are some hint which is given. And if the advertisement is silent, how the people will come to know that what is the guideline which is applicable?
This judgment is also based
Nobody
on
would come to know.
same advertisement.
They will follow with the guidelines. If the guidelines does not indicate that what are the documents you are supposed to give, then in that event it is not
So,
necessary.
Your Lordship, the guidelines clearly
if
say
those
that documents
are there.
with regard to nativity
And they have said that what are the documents you should, which does not contain the residential certificate.
But then this judgment, Your Lordship, squarely covers it.
In this,
No.
this
We'll distinguish it on the facts.
the candidate has assured to furnish because she
Undertaking was given.
Suggestion.
on the date of application, she did not have that precedence to say, and she undertook that she has applied for procedure has not granted it. But there is no discussion with regard to advertisement requiring her to produce this certificate.
This could have been done.
In both the cases, the undertaking was given.
Is there any
And guideline. Yes, Lordship, in guideline in para B says you have to produce documents. If Your Lordship, kindly see page 31B.
Please.
15 days time will be given to the candidates to apply to the CDPO along with the documents in support of the nativity.
Correct.
15 days is the last
So
date.
whatever, now it is the 17th, she had those documents in her possession. If the authority has fixed on the 17th day, so she will go and produce on the 17th.
Your Lordship, 15 days was for the filing of application. 16th day is for scrutiny. Now,
No,
in our case,
where it says
B and C, 15 days is for the candidates to apply.
Correct.
16th day is for verification of document.
No difficulty.
Now, till 15 days, she did not have the certificate.
Whatever,
So application will be
says that apply along with the documents in support of a nativity,
yes,
educational qualification, caste and other.
So no documents.
Now what is the meaning of the word nativity?
The residence certificate is to file. She did not file any
What
document.
is the general meaning of the word nativity?
That she is a resident of that area.
Does it mean?
Yes, Lordship.
Very restricted meaning. Nativity.
May I clarify, madam? In this advertisement, it is not a requirement.
I see, that is what I say.
But in the
These
earlier,
unsuccessful candidate become desperate. If I am not chosen, I will not allow anybody to.
But what my learned friend is saying, in the guideline, it was there earlier with the requirement that you file an affidavit that I belong to this place. It was there earlier, but in this advertisement, it is not there.
Residential.
Residential. Nativity is something. You are confusing.
We'll have to then assign a meaning of the word nativity. That's organized. And if the advertisement does not indicate, indicates the other documents, then in that event, if those documents are there, only thing is the proof has to be given at the time of litigation. She has provided a proof at the time.
Proof has to be given along with the application.
But this is the only thing that
Also, Your Lordship, the date of verification of documents, that has to be on the next working day.
These are all the authorities. What they will do? What is the
Again, Your Lordship, the guideline says that it has to be on the next working day.
No, it is not mandatory that it has to be done on that. The word will is used.
Yes, Your Lordship.
So it's not mandatory. And there are principles of law. If a particular person or a litigant is required to do a certain things within a period of limitation, then it is always regarded as a mandatory provision.
Even
and if the government or the authorities are required to do within a time frame, then it is never regarded as a mandatory. It is always a directory.
Deferment of this date of scrutiny is also okay, Lordship.
So
But
that
application
principles also come.
Application, this judgment clearly says application is incomplete.
It is the verification is to be done by the authorities, sir.
Verification of the documents that has been
Sir,
filed.
who will do a verification?
The authority, Your Lordship.
If they decided to do it on 17th day, what is the fault of those candidates? Tell me.
Your Lordship,
You are saying that why
I bow down to that, Your
should be
Lordship.
16th
But
day.
then the application was incomplete. Verification, they decided that they did it. I bow down.
It does not contain only the residential certificate. That's all.
Yes.
Incomplete is the access.
Yes.
So nativity, let us decide.
Obliged.
Noted. 16, 17 days.
16, 17, I'm also not on that. With regard to completion of the application.
You have those line of judgments that the application must be in consonance with the advertisement.
Well, I have only one judgment that Learned Civil passed in similar type of case, accepting that they can produce on 5.2, even if he has not filed it along with the application. That is the para I have marked my Lord. The same, there's 13, paragraph 13.
Keep this matter tomorrow first. Yes, I'm keeping this matter tomorrow, the first matter, and I'll take it off.
Okay.
Oh, bless me.
May I have your time leave to mention item 20?
So tax matter, labor matter, may be listed tomorrow.
And let's see, item 46, my lordship, kindly let tomorrow to urgent, my lordship. Selection has been made, appointment note has been given to the. May I have a lordship, kindly to mention item 20, your lordship?
This is you.